I'm led by Senior Counsel Pain Chaudhary, person taken consent from the Council of the Cabinet also.
All right, item 22, right, on the request of Mr. S.C. Kyle and a counsel for the petitioner made with the consent of the opposite party, this matter stands adjourned and shall now be listed again on Friday for motion as a fixed item.
Much applied.
May I, Your Lordship? Lordship, I'm mentioning for a listing of a matter. It was matter is
page 48, madam. Three charges, whereas serving a so-and-so registered society and the secretary so-and-so during your tenure, the state society, you have misappropriated 30 lakhs of money from this fund and 670 quintals of rice and also did not distribute the after agent. So three charges are framed. So when this inquiry was going on, I have prayed for time to file the WF and also this charge, memorandum of charge, no statement allegation, list of witness or documents. Whatever way, I have prayed for time. Subsequently, when this is pending, my lord, subordinate officer, there is Annexure 9 has been issued for another inquiry. That is my case. With reference to subject, the undersigned is inquired into the matter of allegation of corruption by you as Guardian Secretary. Accordingly,
Another inquiry on the same charge.
same charge, my lord.
Let us see the two memorandum.
Yes, my lord. Yes, my lord. The memorandum, my lord, here on a complaint, my lord. These are that also I have submitted, my lord, complaint.
No, is it not annexed to the writ petition?
My lord, that is a miss, my lord. But complaint is there. On the basis of a complaint, this notice has been issued, my lord.
Show the notice. Which is the notice?
Yeah, notice is this one. This one is the notice, my lord. That is a letter dated 25/1/21, and this is the complaint. There is a mention about this complaint, my lord. In the letter itself, to hear the matter of complaint petition, my lord.
Which page?
Page 49, my lord. Page 49, same charge, my lord. Accordingly, a hearing is fixed on 3/2/23 at 11 a.m. in the office of the Registered Society to hear the matter of complaint petition. That is the complaint, my lord. I have missed to file the complaint. Your complaint, you will find same charges, my lord. Subordinate officer is taking hearing. So I have said that how it is maintainable. So can you look into the matter? I have prayed for this. It is not maintainable. Same charge, my lord.
And where is the previous one?
A previous one is the, my lord, the earlier page, my lord. That is page 48. Here also same.
Yes, what do you have to say?
Yes, your lordship.
Then, my lord, when I said that this is so and so, another focus has been issued, my lord. That is at page 50, my lord, by registrar. There, while you were serving as secretary so and so, you are directed to appear before the undersigned on 3/2/23. Well, same that letter, partially that letter. To inquire and so that the secretary had neither appeared hearing nor date in time nor submitted written statement so and so. You are hereby charged with disobeying the order.
Yeah, why did you not appear?
On the same charge, I have said, I have submitted my.
Why did you not appear before the authority?
No, because same charge, because we have registrar is taking the hearing, my lord. Registrar is.
This is by the register page, annexure 10, page 50 is by the register. You did not appear before the register also.
No, that occasion did not arise, my lord. Registrar did not ask me to appear before. This is additional registrar. This is additional registrar, my lord, not the registrar. That situation did not come. When additional registrar issued this one, then I have said that inquiry is going on by the registrar of society. So how again hearing is taken place? Only I have replied that one. So registrar issued this one again.
So have you submitted a show cause notice, reply against the notice dated?
Reply, I am taking time to, because the document is a matter of documents, my lord. I have prayed, this is the annexure 13 and annexure 12. These are the annexure 12, this annexure 11. I have submitted. Please give me some time so that I can file that. Yes.
Yes, what do you have to say?
Yes, your lordship. This
And-
is followed through a complaint. Lordship, if your lordship is page 48, annexure 8, your lordship. This is a so called notice where the memorandum of charge is mentioned, your lordship.
Where is the memorandum of
The
charge?
charge is mentioned, your lordship. Their allegation of misconduct, para 2, 3, and 4, your lordship. While you were serving as senior inspector, auditor, cooperative societies of the office of the
No,
assistant.
you are Mr.
V. Rajko, your lordship.
Rajkumar. See, this appears to be page 48 is a show cause notice.
Show cause notice.
Where is the question of charge in show cause notice?
Yes, your lordship.
Then why have you issued show cause notice?
Yes, show cause notice was issued with time frame is.
We'll stay the entire proceeding. Your officers don't have the elementary idea of how to conduct an inquiry.
Lordship.
First, you issue a show cause notice,
Lordship.
and in that notice, you say that why penalty should not be imposed on him.
Lordship.
You are creating we'll write it in the order that these proceedings are generated due to lack of understanding or deliberate negligence of the officers.
Lordship.
No, say something.
Yes, your lordship. Yes, lordship, it's not a record of evidence, your lordship, but the charge is.
I want to know this 3rd January 2023.
Lordship.
What is it? Is it the initiation of DP? Is it a show cause
No, your
notice?
lordship, this is a show cause notice. your
Then why
lordship.
have you
But
mentioned about the penalty in show cause notice?
You are therefore charged for misappropriation.
Show
of the
cause notice
society's
is
fund
issued to.
and violation, yeah, yes, your lordship. Language, your lordship.
You withdraw all this by afternoon today, or I'll direct personal appearance of the registrar.
Will withdraw, will.
Withdraw it.
And will issue a
And
press.
tell them that they should do
Press.
some little bit of study. They don't seem to know anything.
Will
I'll
withdraw.
call it after 1 hour. You ask them.
I will
What
take
is
it,
all this nonsense generating litigations one after another?
lordship.
In a show cause notice, you threaten him with penalty. That means you have made up your mind.
Lordship.
The whole process will have to be interdicted by the court now.
Lordship,
This
will
is all deliberate to give benefit to the petitioner. Looks like
Lordship, there is a complaint which is there, your lordship.
maybe
Based on the
you
complaint,
follow
and
the
earlier-
process and proceed against him. You follow the process.
Yes, yes. your
You issue a show cause notice and threaten him with penalty in that. And then say that you have not appeared for hearing, recording evidence. What is all this?
I'll take instruction, lordship will. grant-
1 hour, after 1 hour.
Lord. Right. All right.
Keep this. By doing all these things, you are not only complicating matters, but giving undue advantage to the
Lord.
delinquent. So we'll find out whether it is deliberate or not. It could be deliberate only. He is an IS officer, he doesn't know this. These are elementary things. He has referred to the provisions of the rule. Has he not read it? You tell your clients that these are the questions the court has asked and the court wants an answer. Or else we'll ask him to
Lordship,
come
this
and
is the
give
so-called
us.
notice, Your Lordship. He has sent for a
Then why
departmental
have you
proceeding.
threatened him with a penalty in the so-called
Yes, that
notice?
is Your Lordship.
You withdraw
I-
it. Withdraw
We'll
it.
withdraw it, Your Lordship. We'll withdraw it.
I want to see the order of withdrawal
Lordship. I'll take instruction, Your Lordship, will grant me sometime.
after 1 hour.
May it please, Your Lordship. My lord will kindly peruse the last order, my lordship. The issue involved in the petition will be cleared.
Lord, I was directed to obtain instruction
Hmm.
whether unmarried candidate, female candidate can be selected or not. That can be one.
Unmarried candidates can be
Can be
selected.
selected because some my lord unmarried, some aged woman is there. They are also women, my lord. Only girls is there because if I say not given because after marriage they will go. That is the idea. Now if here in women means unmarried also. They can be selected.
My
So
lord will
your only
kindly-
ground is.
That is the only ground.
But my lord will kindly peruse page 49, my lord. Page 50.
Hmm.
My lord, the wording is very simple, my lord. Married women should be selected from the local village where the Anganwadi center is established. There is an exception only in case of a divorced woman or a widow, my lord. Had there been something that
So
aged.
therefore, they will have to now file an affidavit
Yes,
and
my
we'll
lord.
have to
And
decide.
in fact, in the advertisement also it is mentioned that only married women will be selected, my lord.
Correct. So now he has taken a stand that unmarried women are also allowed. Let
Yes.
them file affidavit. If they find the statement is incorrect and has been deliberately made, we'll initiate action against the officer who swears the affidavit. But till such determination, you can't get any relief.
Yes, my lord. But
You
my lord-
understand that?
Yes,
Stay will not mean your client will be.
yes, my lord.
All right. So I heard Mr. K. Mohammed Lanik, counsel to the petition. Also heard Mr. T.C. Chutia Lanik, additional senior government advocate Assam appearing for the official respondents.
1,
Yes.
2, 3, 4, and 5.
Responding numbers 1 to 5. In terms of the order dated 15/3/2023 passed by this court and submit that the advertisement notice does not impose a complete bar for appointment of unmarried women. First up, according to Mr. Chutia, unmarried women of a particular age group can participate in the selection process, and to that extent, the same cannot be faulted with. Full stop. Mr. Chutia, however, prays for 3 weeks' time to file affidavit responding to the allegations made in the writ petition. Stop. Issue notice of motion returnable in 4 weeks. Since Mr. Chutia has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition requisiting numbers is furnished to the landed government advocate. Assam. Full stop. It is made clear that appointment, if any, made to the post of Anganwadi worker and oblique or helper pursuant to the advertisement notice dated. What is the
Five.
date?
My lord, 5/12/2022.
5/12/2022.
In respect of 3 Anganwadi centers, my
In
lord.
respect of which Anganwadi you are
My
concerned?
lord, 17 number Balesar 2,
In respect of,
2004, 204 number Dayabasna, and 36 number Chaikot.
you are concerned with all the 3.
Only 3.
Where does one find the names?
My lord will kindly peruse the advertisement, my lord. Page 30.
Page 30.
My lord, page
30.
30. My lord, page 27. Anganwadi worker, serial number 3, my lord. 204 number Dayabasna. This is with regard to petitioner number 2.
204 number Dayabasana, Anganwadi Center. Then,
My
which
lord,
are,
then 2 helpers, my lord. Anganwadi helper, the last, my lord. Below, the 8 and 9. 17 number Balesar and 936 number
17
Chaikot.
number Balesar
Two.
dash Roman 2, Anganwadi Center, and 36 number Chaikut, Anganwadi Center shall be subject to further orders that may be passed in this case. Page 27 of Pavan Namgida.
My blessing.
But I'll dismiss your petition. You can't join, three of you can't join in service matter.
But my lord, the issue involved is from a same advertisement.
Nothing. If you succeed, one of you may succeed, others may not. Then the whole writ petition will be dismissed. So I'll dismiss it, but we'll do it after Bihu. Yes.
Wait till your lordship.
My lord, I filed caveat in this matter, lordship, but it was not served. I have collected the copy, lordship.
Caveat was lost subsequent to
No,
filing.
14, sir.
Anyway.
Anyway, I have collected the copy, lordship.
Very well. You are welcome.
Yes.
Yes.
Under this matter relates to selection of ground pradhan.
Hmm.
And in this matter, my lord, the petitioner is a son of the earlier ground pradhan. And the private respondent here, he is an assistant teacher of the MA Madrasa. And I have filed documents to show that.
Respond number 3 is serving as an assistant teacher.
Yes, my lord, in MA Madrasa.
Madrasa is closed.
Yes, but that has now become school, my lord. But the documents that we have collected at the when my lord he was
Your client is working as assistant.
No, lordship, he resigned before application, lordship. He resigned on 2/8/2022, lordship, and then applied, lordship.
So there are orders passed. Let them verify before issuing appointment.
Yes, my lord. In fact, your lordship had passed earlier orders. One of the orders I may, my lord, would be before lordship. But when we, my lord, move this earlier petition, when your lordship has passed this order, my lord, I was not aware of the division bench order. Because, my lord, my case was that an appeal does not lie against the selection. It's only against, my lord, the appointment. But then, my lord, division bench has made it clear that selection and appointment is one and the same thing. Both. But then, my lord, that judgment also I may place, my lord, before lordship. But then, my lord, that remedy is also not efficacious in advance. My lord, there is no power has been given, my lord, for stay. So, although that alternative remedy is there, but that may not be efficacious because the power of stay has not been, my lord, specifically.
No question of stay. If one these are factual issues.
Yes, my lord.
The writ court cannot verify.
Yes, sir.
So ultimately, if there is a statutory apparatus which can verify,
True.
then that has to do it.
So that
Within 60 days, they will either say your client is entitled to relief or not.
but then, my lord, we have come at a stage when the selection has been made, but the appointment has not been made. That is the stage we are in.
Hmm.
So that way, my lord, the earlier order covers that, my lord, that will protect the petition.
No, but what is the ground not to prefer statutory appeal? The other day, your submission was something else.
Yes, my lord.
But this court has been consistently directing parties to avail statutory remedy.
My lord, that your lordship may also direct me, but till that is decided, they will not make the appointment. That is one of the options. Other option is that they'll verify, my lord. After all, my lord, in the appeal also they'll verify the document.
So no appointment order be issued until the allegations are verified. That's all.
Right.
All right. Take down. Heard
After
this.
verification, yes, after verification of the appointment, they will bring further. Fine.
Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. A. Barkotaki, learned counsel for the writ petitioner. Also heard Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the respondent number
2, my lord.
2 and Mr. Mr. S. Datta and SC Revenue and Disaster Management Department Assam for respondent number 1 and Mr. T.C. Chutia, learned additional senior government advocate Assam for respondent number 2. Mr.
M.K. Hussain.
M.K. Hussain, learned counsel has appeared for the respondent number 3 on the basis of a caveat. The petitioner herein had participated in the process for selection of the post of Gauprandan under lot number 9, Romari, falling under Botadrava Moja under Dihing Revenue Circle in the district of Nagaon in terms of the advertisement notice dated 05/2022. First stop. The selection process ended in the respondent number 3 being selected for the post of Gaupradhan. Full stop. The petitioner has approached this court by filing the instant writ petition inter alia contending that the petitioner, the respondent number 3 is a government servant and he is also a member of a political party. Stop. Therefore, the petitioner does not meet the eligibility condition under the advertisement notice dated 5/9/2022. Full stop. Mr. Chutia, current government of Advocate Assam, additional senior government advocate Assam, on the other hand, has argued that there is a statutory remedy available to the petitioners under Rule 162(c) of the executive instruction framed under the Assam Land and Revenue Regulation, and therefore the petitioner be directed to avail of the alternative remedy. Responding to the above, Mr. Chaudhary submits that his client would avail the alternative remedy, but some interim protection is required in this case. Full stop. After hearing the submission of learned counsel for all the parties and in view of the facts and circumstances of this case, this writ petition is being disposed of by granting a week's time to the petitioner to prefer an appeal under Rule 162(c) of the executive instruction before the Commissioner of Central Assam.
Yes. Central.
Before the Divisional Commissioner Central Assam, assailing the selection / appointment of the respondent number 3 as Gaon Pradhan. Full stop. If such an appeal is preferred within a week by annexing a certified copy of this order, the authority, the appellate authority may hear the matter and dispose of the same within the statutory period by a speaking order. Full stop. It is also made clear that if no order of appointment has been issued till now in favor of respondent number 3, the same shall not be done without proper verification of the complaint of the allegations made by the writ petitioner. With the above observation, writ petition stands disposed of. Which are the other matters?
My lord, 5, 6, 7, 1 line submission may be recorded. He resigned my submission.
Mr. Mr. M.K. Hussain, however, learned counsel for the respondent number 3, however, submits that his client had resigned
Before application.
from the government job before submitting the application for the post of Gaon Pradhan.
My lord, 5, 6, 7, 8, and 9, they are, my lord, identical. They are, my lord, all the petitioners are sons of the earlier Gram Pradhan. And these private respondents are, my lord, members of political party. And my lord, so far as item number 11 is concerned, my lord, that I seek leave to withdraw the case because my lord, there is some formal defect. I'll file it again.
So 11 are like of Mr. M.P. Chaudhary and senior counsel appearing for the petitioner seeks leave of this court to withdraw this writ petition with liberty to file again after rectifying the formal defect. The prayer is not opposed by the learned government advocate Assam. In view of the above, this writ petition stands disposed of on withdrawal with liberty as paid for. Other matters, let us see which is the item.
I think I am
5, 6, 7, 8, 9, and 13. My lord, 5, 6, 7, 8, 9 are identical. Their petitioners are sons of the earlier Gram Pradhan, and the private respondents are members of political party. And so far as 13 is concerned, my lord, the private respondent does not have the my lord educational qualification.
Identical with separate orders will have
Yes.
to pass.
In 5, I am appearing. 5, 8, and 13, I am appearing for private respondent.
Call file as the matter comes with those orders. Yes.
So item number 5.
item number 5.
Mr. M.K. Chaudhary and senior counsel listed by Mr. Eva Kotabi and counsel for the writ petitioner. The petitioner hearing had participated in the selection process for appointment of Gaon Pradhan under lot number 8/9 Chamaka/Kubai Kata under Bottodrava Moja of Dihim Revenue Circle in the district of Nagaon. As per the advertisement notice dated 5/9/2022. Upon conclusion of the selection process, the respondent number 3 was selected for appointment of Gaon Pradhan. Full stop. According to the petitioner, the respondent number 3 is a government servant.
No, my lord. Respondent 3 is a, my lord, the member of Indian National Congress. The political party.
No, but in the synopsis, government servant is also mentioned.
No, my lord, there is a mistake for him. I am sorry.
According to the petitioner, the respondent number 3 is a member of a political party and therefore not eligible to apply as per the terms and conditions of advertisement notice dated 5/9/2022. First up, Mr. M.K. Hussain, learned counsel for the respondent number 3 stroke caveat, however, has denied such allegation made by the petitioner's counsel. Full stop. Mr. T.C. Chutia, learned additional senior government advocate Assam, as well as Mr. S. Datta, learned SC, Revenue and Disaster Management Department Assam, submits that there is a statutory remedy available to the petitioner under Rule 162 bracket C bracket close of the executive instruction framed under the Assam Land and Revenue Regulation 1881, and therefore this writ petition be disposed of by directing the writ petitioner to avail such alternative remedy. Full stop. Mr. M.K. Chaudhary, learned senior counsel, has agreed to such a proposition, but submits that the interest of the petitioner be protected by an interim order. Full stop. Having heard the submissions of learned counsel for all the parties, and keeping in mind the facts and circumstances of the case, this writ petition is being disposed of by granting a week's time to the petitioner to file an appeal before the Central Assam Divisional Commissioner. If such an appeal is preferred within a week by annexing a certified copy of this order, the same may be considered and disposed of in accordance with law by a speaking order within the statutory period. Full stop. It is made clear that if no order of appointment has yet been issued in favor of the respondent number 3, then the same be issued only after proper verification of the allegations made by the writ petitioner. With the above observation, writ petition stands disposed of.
6.
Item 6, my lord, the petitioner Abdul Hannan is the son of the earlier Ram Pradhan, and the private respondent is a member of a political party, AZP.
You are for respondent number 3.
Yes,
So Mr. S. Alam for
Lordship,
respondent number 3.
so for my submission, Lordship, no stay order may be passed, Lordship. Nothing has
All
been
right,
endorsed.
the petitioner, line head is the son of erstwhile Gav Pradhan, and he has participated in the, Mr. S. Alam, you filed caveat.
Lordship, on Monday, I filed caveat, but it is not.
S. Alam caveat, Baki said, yes.
Lordship,
They will verify before issuing an appointment order. We'll pass this order. Disposed of. Baki
Item
okay.
7.
Same as 5. Khali ato line son of erstwhile Gav Pradhan.
7.
Then it also, my lord, the same, private respondent is a member of the BJP. I have annexed the list to show that he is a member of BJP.
Petitioner son of Gav Pradhan.
My lord.
Petitioner son of Gav Pradhan. Respondent number 3 can appear for me. Baki same disposed of.
8.
It is, my lord, the same, exactly similar, my lord. It I am appearing.
Petitioner is son of erstwhile Gav Pradhan.
Right.
Son of erstwhile Gav Pradhan, M.K. Hussain for respondent number 3. What is said?
9 is, my lord, private respondent is a member of AUDF.
I filed a caveat, Your Lordship.
Petitioner
Your
is-
Miss
Begum.
A. Begum for respondent number 3, stroke caveat.
Denied.
Petitioner is son of erstwhile Gav
Yes,
Pradhan. Petitioner is son of erstwhile Gav. Rest of
As
it
per
is same.
mention, Your Lordship, he is not son of Gav Pradhan, Your Lordship.
All right,
then
that they will verify. Yes.
Then item number
So
13.
all of them are Central Assam, Division Commissioner,
Yes,
Central Assam.
Or from Nagaon district, my lord. Item number 13, my lord.
Hmm.
Of course, it's not really.
Hmm.
For your
Yes, yes.
Item number 13, my lord. The petitioner is a son of a Ram Pradhan, and the respondent number 3,
Hmm.
he does not have the educational qualification, my lord. That,
Son of, item 13, son of erstwhile Gav Pradhan does not have the educational qualification. A2 over ground. Mr. M.K. Hussain, you're on caveat.
no, Lordship, by filing Okalap, no, Lordship. I yesterday filed.
Caveat na lage, respond number 3. But the order will be same. So that complex Nagaon district,
Yes, my lord.
which is the next district you want to go?
Golpata, my lord.
Barpeta, okay. Friday?
What happened?
Item 10.
I am highly overwhelmed.
May I please, Your Lordship. Petitioner is agreed with the transfer posting from APS Guwahati to SSG Noida. Lordship will find the impugn order at page 18, Your Lordship. And the relevant part at page 20, my lord. At serial number 220 from ASG Guwahati to SSG Noida, Your Lordship. Lordship, thus as per circular, may I take your Lordship to page 30?
Just 1 minute. All of streaming to one o'clock, sir. Live streaming. Just check the body of Mr. Martyr has been brought or not. Just check where it is. I may rise for 2 minutes and just go there. Tell them.
Lordship, circular as regards to the transfer posting, that is a guidelines. That is a guidelines, Your Lordship, for the transfer posting. Your Lordship will find at page 30. That is in the unit station, that is the minimum, that is tenure is 3 years, Your Lordship. Minimum, Your Lordship will find at page 30.
So you are challenging this transfer order 7th of March 2023,
Yes, my lord.
by means of which you have been transferred from
From APS Guwahati to SSG Noida, Your Lordship.
APS Guwahati to SSG Noida.
Yes, special security group, Your Lordship.
All right.
It
So
is-
what is the ground of challenge?
The first ground is that within a span of 9 months, Your Lordship, this is the third time transfer. So far the petitioner is concerned. Apart from that,
Are you staying with your family?
yes, my lord.
in
And that
Guwahati?
he has also taken admission for his children, 2 minor children. That is, I have annexed the admission fees received, that is at page 40, annexure D, Your Lordship will find.
Hmm.
He has taken admission because he had a legitimate expectation that only 6 months have gone by from his posting at the APS Guwahati. That is why he has taken admission. And the frequent transfers causes financial loss and difficulties. for
Yes,
them also to settle.
Mr. Goswami.
What I am, although he is seeking a direction for stay of the order in view of that short-term duration. My explanation, I have the instruction. The petitioner last posted at Goya, and on 8/9/2022, he promoted and transferred to LGVA, and accordingly, he is continuing here. What happened, now he is a specialist trained person, because earlier he was city constable GD. Now he promoted to the post of head constable GD. That is the promotion order, promotion and transfer. Now, his service is required because he is a special wings. He is under the special wing of the CISF. SSD, his for security of the VIP, this trained person's service is required. That is why he, along with him, the numbers of transfer that order is reflected. They are sought to posted at various places, and most of the places are in the SSG Noida. His one of the ground before the honorable court is that for the guideline. 2017 gallery annexed that guidelines that duration is earmarked for where the home as well as how the transfer can be carried out. But along with that guideline, there is a specific silent pieces are there.
Please don't put it in the mic. Creating a noise, you can hear it. No? Yes.
The silent features are there. Clause 10, 10C,
Page
page
numbers.
24. There it is clearly mentioned, it is again clarified that these guidelines would only serve as broad parameter for posting of personnel, but the final decision will be raised on the competent authority of CISF and will be governed by the operational and the administrative necessity of the force. Here is a necessity. That is why for the purpose of VIP security, he was sought to, he is a specially trained person. Now, unlike all other persons, he was promoted. That is why his service is required to that. That is why this imping transfer order. And so he has submitted a representation. In this regard, also in my instruction says that in view of this requirement of his service, that cannot be considered at this stage, Malad. His specialized capacity that required for that the VIP security. So the imperial order maybe
Lordship,
may not be
that sector has been set from airport security group. He has been transferred to the SSG group. That is for the administration function. Lordship will find at page 38.
No, are you alleging malafide? Are you alleging malafide in this?
Yes, my
Where is the statement? This order of transfer is issued from which place?
That is the imperial order. Yeah, that's-
I'm asking Mr. Goswami.
Malad. From
Mr.
That is at
he is presently posted at LGB Guwahati. He was sought to transfer to that
Where,
Noida.
who has issued the order of transfer?
Malad.
at para 10 I have stated.
The Additional Director General of Airport Sector, Central Industrial Security Board. I issued this order.
And just Lordship, one more aspect. May I take your Lordship to page 38 in Excerpt C? Out of home zone tenure should be 7 years as per the circular. Lordship, till today, he has spent about 15 years, 8 months, 17 days in the out of home zone. Again, he has been transferred to the out of home zone sector, Lordship, whereas he has spent only 2 months, 23 days in the home zone till today, your Lordship.
So transfer order cannot be stayed. What others?
No,
What can
Lordship,
else
the
be done?
representation has been made before the competent authority. So they can look into that, your
Where is
Lordship.
the representation?
Representation at page 41, that is through proper channel. And another representation that is submitted in an online mode as a grievance, online grievance, that is at page 43, Annexure F and Annexure E. Lordship, till then, my Lordship. And
Has the representation been disposed of?
No, Malad.
It is
Representation.
Heard Mr. D. Borwal and counsel for the D. Borwal and counsel for the petitioner. Also heard Mr. UK Goswami, Lanet CGC appearing for the respondents. The petitioner has approached this court assailing the transfer order dated 7/3/2023, whereby
22.
2022.
Yes, Lordship.
7/3/2023.
23, Lordship. Yes.
Why are you interrupting the court?
I'm sorry. Yeah.
23, by means of which the writ petitioner, who is presently posted as head constable in the LGBI airport, is it LGBI airport?
LGBI.
The petitioner, who is a head constable and a CISF personnel posted at the LGBI airport at Guwahati, has been transferred and posted at the
SSG Noida.
SSG Greater Noida.
SSG,
Yes, my.
SSG. Greater Noida. Full stop. According to the petitioner, this is a case of frequent transfer in violation of the policy followed by the CISF. Full stop. Mr. Bora submits that he has recently got both of his minor children admitted in a school at Guwahati by paying the requisite fees, and therefore shifting them at this stage would pose tremendous difficulty and harassment to the petitioner. To stop. It appears that the petitioner has submitted a representation dated 15/3/2023 to the Additional Director General from Airport Sector, CISF, ventilating his grievance in the matter. Full stop. However, Mr. Goswami submits that the said representation has not yet been disposed of. Full stop. The learned CGC has also made clear that the move to transfer the petitioner is in exigency of public service, since the petitioner is a specialist in VIP security. Be that as it may, since the petitioner has submitted a representation expressing his difficulties before the competent authority, the same deserves to be looked into by the authority. As such, without expressing any opinion on the merit of the case, I dispose of this writ petition by providing that The respondent, respondent number,
Respondent number, Lordship,
so and so may consider and dispose of the.
respondent number 3.
Respondent number 3 may consider and dispose of the representation submitted by the petitioner as expeditiously as possible. Full stop. A copy of this order be furnished till such time the representation is disposed of. Status quo be maintained as regards the posting of the petitioner. A certified copy of this order be placed before the respondent number 3 within 3 days from today. With petitioner stands disposed of. I am rising for 5 minutes. We'll come back.
Malad, father was for employee of the, phone number 5, Malad. He died in Hanes on 1909 to 12. He applied on 2010, 2810 to.
Mr. N.I. Mother, we are on counsel for the petitioner. The matter pertains to prayer made by the petitioner for appointment on compassionate ground, which was declined by the SLC.
Yes, Lordship, for the 2 times he was rejected.
Hmm. On the ground stated herein. You don't have a case, what to do?
Malad, any other post, any other divorce.
On kindly page 28, annexure 6.
Since the learned counsel for the petitioner has submitted that the case of the petitioner could have been considered for any other post in the same category. Ms. S. Borua is granted 2 weeks time to obtain instruction and response to respond to the same. 2 extra copies of the petition is furnished to her and let this matter be listed for motion again after 2 weeks.
Item 14.
May I please also? Actually, I am a victim of Assam movement, Your Lordship.
We'll decide this. Don't you think it is a little too early, premature? Assam movement was when?
Lordship, but I have annexed some similar order, Your Lordship, which is covered me, Your Lordship, at page number 36, Lordship, Your Lordship.
Page number?
Page number 36.
No,
34,
but
Your
why have you come after such delay? You have to explain it to this court.
Lordship. Page number 34, Your Lordship, main order. Page 36, para 4, Your Lordship.
No, Lordship, may kindly have a look, page 38.
Lordship, before page 36, Your Lordship, para 4, Your Lordship.
Yes.
On hearing the learned government as well, the learned standing council for health department, this court is viewed that read petition can be disposed of at the motion stage itself. Accordingly, if the petitioner applies for a government job post with its advertised and selection process is initiated by the government, the respondents would have to determine whether any quota is reserved for filing up the said post by way of 1999 rules, and the respondents would also have to verify that the petitioner has applied under the quota reserved 99 rules, and whether the petitioner is member of family or matter or disabled person as provided same rule. Besides verifying the genuineness of the documents furnished by the petitioner, that the petitioner can be considered for the appointment against any vacant post in terms of 99 rules, for which selection process has been initiated by the respondents. Participation in the petition in the selection process will be subject to the petitioner having all the requisite eligibility criteria for the said post. Lordship, only my prayer for prefer, Your Lordship,
kind
after
of order
verify of
should
my
have-
documents, Your Lordship.
If they decide to have a quota, if the petitioner applies, if he is eligible, then a mandamus is issued to consider his case. It will be difficult for this court to
A
pass. an order.
certificate, Your Lordship, issued by the deputy commissioner, page number 32, Your Lordship.
What is page 38?
30 is another order passed by this honorable court. The relevant portion is page 39, my lord. Second paragraph, may I read, my lord? I'm a sensible learned studying, so respond number 1, learned. The read petition is premature in as much as there is nothing to show that the petitioner has applied for any government post in pursuant to any advertisement or selection process undertaken by the government. They, however, submit that the case of the petitioner can be considered in terms of the first decision taken by the government, provided that the petitioner is a member of the family of a martyr or disabled person, and the petitioner applied for a government post under when the selection process is initiated by the Assam Public Service Commission or the government. They also submit that the genuineness of the certificate issued by the authorities as annexed in the writ petition would also have to be verified by the respondent, beside the petitioner requiring to have all the eligibility criteria required for being considered for such advising post. The lordship, in this case,
Lordship,
petitioner
last para,
himself,
Your Lordship, last para is
petitioner
the
himself.
observation, Your Lordship. Accordingly, Your Lordship, last para, Your Lordship. May kindly continue, Your Lordship, last para.
Hmm.
Accordingly, the petitioner applies for a government post which is advertised and the selection process has been initiated by the APSC or so. Otherwise, the respondents would have determined whether any quota reserved for filing of the said post by way of 99 rules. If such post is filed by the way 19, the government will, they have to verify whether the petitioner is a member of the family, martyr or disabled person as provided 99 rules, and besides verifying the genuineness of the document furnished by the petitioner. If the petition is found to be a member of the family or martyr disabled person who can be considered for the appointment against any vacant post in terms of 19 for which the selection process have been initiated by the APSC or otherwise participant of the petition in the selection process will be subject to the petition having all the requisite
Is there any quota for the martyrs for the?
Lordship, there is a
Lordship,
lordship.
I will look the rules for a moment, 99 rules.
Hmm.
My book is page 127, my lord. Is the Assam Public Services Preferential Appointment Rules 1999, my lord. 127. Then lordship may kindly have a look the definition who is entitled under the family of the martyr. Lordship is 2. Then lordship may kindly have a look the application part. 0.3, my lord.
Hmm.
Application. These rules shall apply to all the services and posts under the government of Assam, recruitment to which are made through the Assam Public Service Commission or otherwise than through the Assam Public Service Commission, and preference for the appointments. Subject to the provisions of this rule, wherever any recruitment to services and posts referred to in Rule 3 is made, one affected candidate who is otherwise eligible under the normal rules shall ceteris paribus to given preference in making appointments, lordship. The preference, lordship.
Only prayer for my
But they
paper.
have to
So have you
participate.
applied for any post?
Lordship, applied to your lordship. There is a communication letter, your lordship, page number 20 to 31, your lordship. So many letters, your lordship, admitted, your lordship. Page number 21, your lordship.
Listen, you listen to the question and answer.
Sorry.
Otherwise, we'll do it some other time.
Lordship,
But there is no escape from answering the court's question.
lordship.
These rules will apply if there is a selection process initiated as per the APSC rules, correct?
Lordship.
There, if you can show proof that you belong to a family of a martyr of Assam movement, then in matter of selection, preference will be given to you, correct?
Lordship.
So for that, first of all, there has to be a selection process, a recruitment process initiated. In that recruitment process, you should be eligible and you should be able to participate. Once you participate, if the advertisement does not mention about the preference under Rule 3, then the court can issue a mandamus to give effect to Rule 3. Has that process reached?
Lordship.
Where? Which is there? Where is the advertisement? Show me.
Lordship, actually, lordship, my process for selection decide whether I am member or not, your lordship. In this regard, your lordship, on
No,
First
not
of all,
member or not. Which is the selection process? Where is the advertisement?
advisable not annexed, but admitted that lordship, my application is forwarded from Department.
Heard Mr. I'm closing this petition. Heard Mr. A.R. Karim, Learned Counsel for the petitioner. Also heard Ms. M.D. Bora, Learned Government
Lordship,
Advocate.
may pray for another date, I shall communicate and put it.
Yes.
Pass over also.
Or you want another court?
No, another date.
Now, how these orders can be implemented? I want to refer it to a
Yes, sir.
larger
I
bench.
shall communicate.
I
and
don't
put
agree
the
with these orders.
advertisement and other things, your lordship.
Appeal, my lord, this petitioner preferred appeal also, the appeal is also dismissed. The appeal number is not with me right now. In some cases, the appeal has been dismissed by this honorable division bench.
Why don't you point out these things before the benches when the matters are taken up?
No, this appeal number is not. with
Now
me,
these
lord.
cases are being disposed of in this manner. They're asking you how these orders can be implemented.
Yes, my lord.
But yes, you're saying now. You don't point it out before the learned judge. A time has come when we'll record that due to the lack of devotion of duty of the panel lawyers that these things are happening. How these orders can be implemented? How? This preference can be given only if somebody applies for a post. That can happen only when there is an advertisement.
Yes.
Someone can apply when he is eligible, is qualified. Then if the process is initiated, there is a question of preference. How these things can be disposed of at the motion stage by saying that someday when there is an advertisement and if he applies and if he is eligible and if there is an recruitment, then a mandamus is issued to consider it. How with so many ifs a mandamus can be issued? And how this order will be implemented?
My lord. Because third page, third name lordship, we have submitted, they have to participate in a selection process.
Very sad the way things are happening. Very sad. On the prayer of Mr. Karim, this matter stands adjourned for 2 weeks.
Obliged.
MD Bora, learned government advocate Assam is present on behalf of the state.
Obliged.
Item 15.
May it please the Lord. My lord, selection to the post of Gangura.
Huh?
Selection to the post of Gangura.
Oh, you are also in Nagaon. Mr. M.K. Chaudhary has brushed everything in Nagaon.
My lord,
Hmm.
little bit which are left over.
Hmm.
Leftovers are probably. Leftovers.
It's not a good thing to have leftovers only. Yes,
My lord, that is what, because the persons who.
but you have heard the order.
Well, same word. 15, 16, 17 and 20.
15, 16, 17 and 20. You have preferred appeal?
My lord, we have not preferred appeal. We will be preferring appeal within 1 week, as your lordship has directed. And my lord,
20 I am appearing most for a caveat also.
15,
16, 17
15, 16, 17
and 20.
and 20. In 20, Mr.
M.I. Hussain.
M.I. Hussain for the private respondent. Mr. S. Datta, learned standing counsel, Revenue and Disaster Management Department for respond number 1, and Miss M.D. Bora, learned government advocate Assam for respond number 3, 4 and 5. Rest of the orders are there with Govinda. Only in item 20 you give his name. The petitioner is a son of erstwhile Gaugura. All petitioners are sons of erstwhile Gaugura.
Private respondents, they don't belong to the categories as per the advertisement.
Private respondents are not eligible
Eligible.
as per that is your case.
Mine.
All right, Lordship, but they can approach the authority under executive instruction 160.
Yes, all these matters are disposed of.
Okay. Lovely.
Obliged, Lordship.
Item 18.
Govinda has the orders, no? Let's take it. So lot number, etc. will get in the each case in the sentences.
May it please the lordship. This is a similar matter, lordship, appointment of the Gaugura lordship. The petitioner is the daughter-in-law of the former Gaugura lordship.
Miss M. Nirola, let me consent for the petitioner. Then S. Bora for respond number,
3, 4, 5 and 6.
S. Datta for 1 and S. Bora for 3, 4, 5 and 6.
1 and 2 and 3.
Datta for 1 and
1 and 2.
3, 4, 5 and 6 as Bora. Appointment selection of respond number 7.
Yes.
Disposed of. Your petitioner is son of erstwhile Gaugura.
Daughter-in-law.
Daughter-in-law erstwhile.
Former lordship. Should till then no point.
Huh?
Lordship till then.
So
no.
then verify before issuing appointment, yes.
Item 19.
Every selection of Gaugura has been challenged.
Maximum
We should have a Gaugura court then.
separate court.
May I please, your lordship.
Yes.
The petitioner, the respondent number 1 and 2 published an advertisement, lordship, for recruitment of non-executives. Being eligible, the petitioner applied, your lordship, and he was shortlisted for document verification, lordship. But when he approached for document verification, lordship, his certificate, your lordship, page 23, your lordship.
Who appears for ONGC normally? There is a council.
Nowadays, notice will go as per instruction. I tried to serve copy, but they did not receive.
Who served copy to whom?
I tried to.
Yes, like he was representing you.
Yes, Lord.
Today, I don't know. Malord.
Can you just request the junior of Mr. Sahiwala to come? Notice I will issue, but there can't be any interim order.
Lordship,
So your petition will be frustrated.
Lordship,
You want that?
no Lordship, I'll call Lordship.
Yes.
Malord.
Time being.
Item 21.
May I praise your lordship? Lordship, the petitioner Gavin was serving as the executive engineer in the PWD division, lordship, electrical division. Lordship, on 5/3/2020, he was placed under suspension on allegations of corruption, lordship. Thereafter, lordship, on 3/6/2020, a show cause notice was issued to him, lordship, that your lordship will find at page 22, lordship. Upon his arrest, lordship.
The period of suspension not regularized.
Not regularized, lordship. Lordship, the only, lordship, if I may, lordship. Lordship, if your lordship kindly comes to page 47, lordship. The order by which the, I beg your pardon, lordship. Page 38, lordship.
So let them obtain instruction then. When is your client retiring?
Lordship, he is retiring on 31st of March, lordship. Lordship, the only, lordship, if I may kindly take your lordship to page 38, lordship.
What is the order you are seeking?
Lordship, the order we are seeking is for regularization. The only.
That's not possible today.
I understand.
So therefore, why go into that? I've already said what is your case. Apply your mind. What is the point in doing a full-length argument of your case? When the order will pass, is only ask him to obtain instruction. But if your client will retire now, nothing can be done. All we can do is on the next date, we can issue a mandamus. These matters, notice has to be issued. Heard Mr. A. Chakravarti, learned counsel for the writ petitioner. It appears that while rendering his services under the respondents, the petitioner was placed under suspension during the period from 5/3/2020 to 10/1/2023. Full stop. The petitioner is due for retirement on attaining the age of superannuation with effect from 31/3/2023. Full stop. The grievance of the petitioner is that the authorities are yet to regularize the period of suspension undergone by the petitioner for the purpose of settlement of his pensionary, which is necessary for the purpose of settlement of his pensionary claims. Mr. R. Dhawal, Standing Counsel, PWD, prays for time till 21st of April 2023 to seek instruction facilitating disposal of the writ petition at this stage of admission hearing. NOM 21/4/2023. Since Mr. Dhar has appeared and accepted notice for all the respondents, no formal notice is required to send in this case. 2 extra copies of the writ petition be furnished to the learned Standing Counsel, PWD. Full stop. Register to release this case again on 21/4/2023 as a fixed item for admission. You come up with the decision. Are you aware? What is the decision applicable here? What is the law? You're not aware.
Lordship, departmental proceedings have been pending, lordship.
Departmental proceedings are pending.
Lordship, the only.
So in any case, where is the urgency?
Lordship, the only observation is that in the order of appointing the inquiry officer, the observation is that the proceedings will be subject to the outcome of the criminal case. Since no conclusion could be drawn against the petitioner in the inquiry committee's report, lordship.
So outcome of criminal case, Paul McAntony's case is there. But yesterday I have passed a judgment, check it.
Lordship.
These periods will have to be regularized regardless of whether there is even if there is an order of dismissal, yet you have to pass an order. Otherwise, what will happen to that period? There can't be a service break. He has been reinstated. So please give legal advice to your clients. You are a lawyer. They are unnecessarily creating trouble. The government officials are unnecessary on most elementary, fundamental things. There is one matter of cooperation department I fixed. There is absolutely total misunderstanding of the rules. In the first preliminary show cause, the expression used is why major penalty should not be. So that shows the senior bureaucrats have no idea of how to. That is unnecessarily generating litigations. genuine litigations are getting delayed.
Because of-
These are the reasons. So give them the advice. They will have to regularize it.
My lord.
Criminal proceeding, whatever happens, that
They have-
will be his own problem. Yes, next matter.
May it please your lordships. The issue before your lordship is that the writ petitioners have been serving in a post of almost 23 years as LDA since date of his joining your lordships. But she ought to have to be promoted to the post of manager. And the second issue as your lordship is that she has been not been paid an amount of rupees 4 lakhs of rupees since the date of joining in the year 1996. There is an lack of payment, your lordship. So still date, our representations has not been fruitful, your lordships, till date, and she has not been promoted to the post of manager till date, and his representation has not been disposed of, your lordship.
Well, we'll issue notice at this stage.
Lordship, what is the issue, your lordship?
Are you aware of the judgment which says non-payment of area salary, there is a limitation?
No, lordship.
You're not aware.
No, I have not been aware.
You check up the judgment,
Lordship,
otherwise you will be taken aback
lordship,
when an order is passed by the court.
lordship, lordship.
Heard Mr. H. Burwal and counsel for the petitioner, there is the amendments made in the writ petition. Mr. R. Dhawan, SCPWD,
No, my lord, this is.
SCWPT and
This is
BC,
WPT and BC, my lord.
pays for some time to obtain instruction in the matter.
My lord, I am appearing for 1 and 3. Here 4 is the
Four is the
respondent, my lord. They are employed under, she is employed under 4, my lord.
Assam Paint Types Development Corporation Limited, your lordship.
My lord, that my lord, Angshuman, A. Sharma is the standing counsel, my lord. I think they haven't served
Copy
the
has been
case.
received.
Then I
Yes,
don't-
have copy.
Copy has been received.
So
My
then
lord, I am
his
just
name is
appearing
not
for
shown.
1 and 3, my lord.
Then we'll have it next week by showing the name of Mr. A. Sharma.
Lordship,
My lord.
Heard Mr. H. Burwal and counsel for the petitioner registered list this case again in the next week by reflecting the name of Mr. A. Sharma, Learned SC, Assam Prince Tribes Development Corporation Limited. That is the respondent number 4 in the cause list.
lordship.
I have informed the Deputy Registrar of Cooperative Society, your lordship. He's saying he's drafting the letter to withdraw. Only instruction is required from the RCS. He's inside the assembly, your lordship. Sometime maybe
Right.
tomorrow,
We'll have it on Monday.
Monday, your lordship.
You have understood the point.
Yes, I have.
You make
understood.
them understand. This shows that you have made up your mind.
Yes, your
The entire process will be vitiated.
lordship. Right.
Now you are to ask him and find out what is there any primary truth in the allegation.
Yes.
If you are not satisfied, then only you can charge a memorandum of charge on him, initiated an inquiry. But now only if you talk about major penalty, then what is the point of inquiry?
Yes,
So you make them understand.
I will do that.
There should be fairness in the process. Heard Mr. Senior Learned Counsel for the petitioner, also heard Mr. Rajko Learned SC, Cooperation Department, Assam, who praised for posting this matter again on 27/3/2023 for motion so as to enable him to obtain instruction. It is made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in a suitable manner, if so advised.
Item 19, timing.
So Shaiwala, sorry to trouble you.
No.
We know nowadays ONGC standing council is actually not there. UAPR
Panel is there, my lord.
panel is there. Just wanted to find out, it appears to be a small
Yes,
ticklish.
your lordship, I am myself, M. Shaila, my lord, he's the panel, he may be.
All right. Can you just find out what is this matter? We're not issuing notice, but posting it for motion next week.
Next week, yes.
All right. Heard Mr. Yarstone, Learned Counsel for the petitioner. Also, here is the amendments made in the writ petition, considering the limited nature of grievance expressed in the writ petition. This court is of the opinion that the learned panel lawyer for the ONGC should be asked to obtain preliminary instruction. First of all, as such, copy of this writ, 2 copies of this writ petition be served upon Mr. M. Shaila, learned panel lawyer for the ONGC. Let this matter be listed
My lord, my name also may be shown, my lord.
on 29/3/2020 3. By reflecting the name of Mr. G.N. Sahiwala, learned senior counsel, as well as Mr. M. Sahiwala, learned panel lawyer for the ONGC in the cause list.
Oblige, your lordship.
Stay matters, item 48.
None appears for the petition on call. Miss,
Yes, pass.
what is there in the mobile?
No, my lord, I was just
Nothing
trying to
to-
call the petitioner counsel.
Yes.
May I please, Your Lordship? In this case, my lord, in last occasion, my lord, the respondent paid for time. So file their affidavit.
We have filed our affidavit yesterday, my lord.
But I have not received copy of that.
You have not given him copy.
I do not know if he has received. I've asked my clerk to give the copy, but we'll serve it today, my lord. If he has not received.
Why it has been listed today?
My lord, it's a very simple matter. The allegation is that whether the person representing the workman is eligible to represent him in the industrial under the Industrial Dispute Act or not.
That is the basic.
That is the dispute in this petition. Our claim is that, my lord, he is eligible to represent the workman because he is a member of a national trade union. He is not an advocate, of course, but he is a member of a national trade union, of a registered trade union, that is.
But my lord, section 36 is specific and if your lordship will go.
So we take up for today. You don't want the copy of the affidavit?
Oh, my lord, I have received, I want to receive the copy, my lord.
My lord
Then-
can take up at 2 PM also, because it can be disposed of today itself. It's a very small issue.
Give him a copy. We'll
Yes,
take it up.
I'll do it right.
All right.
Martyr.
Item 49.
My lord, I have received instruction. Some time may be granted to file the affidavit, my lord.
No inquiry, madam.
De novo inquiry. Mr. You are Mr.
He does. He does.
He does. Right, counsel for the petitioner is present. This MD Borough Land Government Advocate Affirm submit that she has received instruction. And therefore be given how much time?
2 weeks time.
2 weeks time to place the same on record in the form of an affidavit. Prayer allowed. List this case again after 3 weeks. Interim order passed on there to continue.
Oblige.
For admission, item 24.
May I please, Lordship? Lordship, I'm on behalf of my senior, Mr. S. Chaudhary. Lordship, may kindly adjourn the matter for today. Lordship, he will not able to do the matter due to his personal difficulty. Lordship, the matter, we have already submitted the adjournment slip yesterday, by taking consent from the other side, Lordship.
When do you want it?
Lordship, we will file affidavit in this matter. Lordship may grant 3 weeks time to file.
You are appearing for the petitioner.
Yes, Lordship, for petitioner.
Petitioner, then what affidavit?
Lordship, the other side submits in the earlier occasion that the petitioner, the legal heirs of the petitioner has stayed in the quarters of in the quarter. Therefore, Lordship, we will submit an affidavit.
Achha, what is your name?
Martyr, Lordship.
Okay, Miss R. Medhi appearing for the petitioner has prayed for adjournment in this case for 2 weeks on the ground that the learned arguing counsel engaged in this case could not come to court today due to some personal difficulty. Since the prayer is not opposed by the learned counsel for the respondents, same stands allowed. The registry to list this matter again after 2 weeks.
Oblige, Lordship.
Item 26.
May it please your lordship, on last occasion, lordship granted me take instruction, my lord, regarding the vacancy, my lord. I have received the instruction. Lordship, in this case, in that period of time, there is no vacancy in grade 3 post, my lord. The lord petitioner applied only for the grade 3 post, and she is a graduate, lordship. so that their case is not considered for grade 4 post. My lord, may directed to consider if he is my senior.
Your Lordship, there is no grade 3 post. Last occasion, my learned friend has submitted before the honorable court. They have kept vacant 3 posts, Lordship.
Hmm.
the I-
Just 1 minute, just 1 minute. Let me recapitulate. So she says 2 persons were appointed by rejecting her application. So if no vacancies were there, how could those 2 persons be appointed? What
Yes,
is your answer to that?
Lordship, may kindly have a look my instructions, second page, my lord.
Hmm.
There is vacancy position of grade 3. That I have stated in my affidavit, Lordship. These appointments are not under the compassionate appointment. Those 2 persons appointed, Lordship, may kindly have a look, Annex 1, page 38, my lord. It is recommended by the state level police recruitment board, that 2 persons. Not so the compassionate appointment, my lord. In our affidavit, you have annexed the letter also, my lord, office order, page 38.
So what is the instruction? Which is the relevant part?
Grade 3, there is no vacancy, my lord.
Hmm. So can you not consider her for any other grade, grade 4?
Yes,
Lordship-
Lordship directed the petitioner counsel on last occasion to take instruction whether she is
Lordship,
grade 4 or not.
Yes, yes.
may I, Lordship, they mentioned about that the last occasion, my learned friend was stated before this honorable court that 3 posts for 3 grade posts, they have kept vacant. For
No, please let her. submit. You take your seat, then you make your reply.
then they mention in this their minutes of the SLCs. They have stated 3 posts regarding WPC number 79414, judgment dated 33/16, and WPC number 2790/2014, dated 26/16, and there is a contempt case number 92 of 17. Lordship. All these cases, the petitioners, the first case in 7/9/2014, in that case, the petitioner was a petition prayed for the 4th grade post, Lordship. And already he has been appointed in a 4th grade post.
No, listen,
And-
please listen. The appointment on compassionate ground
Yes, Lordship.
only seeks to dispense with the queue,
Yes.
but
Lordship.
you have to fulfill the qualification
Yes,
norms,
Lordship.
right?
Yes, Lordship.
Now, as per the rules framed by the state government of Assam,
Yes, Lordship.
a graduate cannot be appointed against a grade 4 post.
Yes,
That
Lordship.
is the rule.
Yes, Lordship.
So therefore, your client's case cannot be considered against a grade 4 post.
Yes, Lordship.
Although ordinarily, if a post is not available in one department, then it can be given
Yes,
in
sir.
another department.
This is the
So
memorandum.
your client is a graduate.
Yes, Lordship.
So she can be only considered against a post where
grade 3.
graduate can be appointed.
Yes, Lordship.
That is grade 3.
Yes, Lordship.
Now, is there any vacancy available in any department?
That is why I wanted to point out that they mention about 3 posts. That is the 3rd grade post. Actually, that is not 3rd grade. That is 4th grade post. And one case they have mentioned 2790. It is not relating any compassionate appointment, Lordship. It is a settlement of fishery matter. They have mentioned in their minutes, as well as my learned friend also on last occasion argued before this honorable court, Lordship. And contempt case also disposed of, stating that the relief was already granted to that. That is why I wanted to state it, and I have filed an additional affidavit, Lordship, yesterday. And I have also mentioned there that petitioner also collected some information from the website of the government. There is 55 posts of grade 3 posts are lying vacant in the department.
You filed an additional affidavit.
Yes, our Lordship, I have filed it. It is placed before this honorable court also yesterday.
Yes. Have you got a copy of this?
Yes, Lordship.
What is have you obtained instruction on this?
Lordship, today only I have gone for the additional affidavit, my lord. So Lordship, may kindly have a look at the page 42, my lord.
No, you tell me, do you want to obtain instruction or you are ready to argue today?
Lordship, I'll get instruction, my lord, regarding the vacancy position right now, my
Yes.
lord.
What has been mentioned in this affidavit?
My lord,
You need to obtain instruction.
my lord,
Then we'll take it up for disposal. That's all.
my lord,
Final disposal.
my lord,
If it is found that posts were available,
my lord.
then the direction will be issued to consider. If it is found that no vacancies are available, then we'll close the matter.
My lord.
Because she cannot be considered,
Grade
she
4,
means the petitioner,
my lord,
cannot be considered for a grade 4 post.
because he's
Because she
graduate.
is graduate.
Lordship, I'll get that instruction.
But yes, you want to say something? You want to say,
No, false statement I have stated.
what is false statement?
And last occasion, she has said there is no 3 grade, 3rd grade post vacant for 3 persons.
No, you filed an affidavit.
I have already filed.
So
This
she
is
is,
stated in our SLC, my lord, all the 3 posts were considered for grade 4 post, my lord. This is-
all right, so you respond to the affidavit
My
now.
lord.
The learned counsel for the petitioner also heard Miss M.D. Bora, learned government advocate Assam, who submits that a copy of the additional affidavit filed by the brief petitioner yesterday, that is 21st of March 2023, has been served upon her. Therefore, she be granted 2 weeks' time to seek instruction and file rejoinder if so advised. Full stop. Since the core controversy involved in this writ petition is pertaining to the question as to whether there was a grade 3 vacancy available on the date on which available for being filled up by way of appointment under the compassionate appointment on compassionate ground on the date on which the SLC has met, it would be necessary for the learned government advocate Assam to specifically respond to the claim made in the additional affidavit. First of, as such, acceding to the request made by Ms. Bora, this matter is directed to be posted again after 2 weeks.
Lordship.
In the meantime, the departmental authorities may file rejoinder if so advised.
Maybe fix
I'm
the
ready.
date, Lordship. Maybe fix the date.
You fix a
On
date?
6th.
Huh?
On 6th April.
On 6th,
April.
6th will be difficult. 12th April, 12th April.
Lordship.
Oblige, my lord.
Item 27.
Lordship, in this matter, advocate Etkedasi is appeared. He is on election code number 1, Lordship. Kindly pass over the matter for time being, Lordship.
Item 28.
My lord, this is related to my lord regulation of our service, my lord, petitioner service. My lord, there is the affidavit filed by the department, my lord, respondent, they have admitted the fact, my lord, she has been working for many years, my lord. And also they have almost stated, my lord,
The prayer is for regularization of
yes,
service.
my lord. And already one similar matter has already been disposed of by the honorable court.
Hmm.
And exactly similar, my lord.
Why this noise comes every time? What is the problem?
I have not get anything. my lord.
No, no,
I
no.
think this one, my lord.
No, this microphone is very sensitive.
I know, if I
That-
turn the page also. Sorry for that.
There is
And when she's been
there is a
working-
ill effect of everything.
I know. my lord. So, my lord, she's been working as a forest teacher, my lord. Forest village teacher, my lord, in Rongchongi, my lord. Forest village school, where, my lord, she has been working since 2002, my lord. And that is against a permanent post, my lord. And that was, my lord, in an interior place, and it was needed for her job service, my lord, because. the
Where is the
vacancy-
admission in the affidavit? Which paragraph?
Yes, my lord, I think so. My lord, page 2, from 3 onwards, my lord. 3 onwards, they have admitted in my favor that with regard to censure, the answering Department of state that on the basis of documented evidence in the form of letters from range officer, DFO, Gigboy, and managing committee of the Rongchongi Forest Village School under Lokkipatha range of Gigboy's division. From field verification, it has been found that the petitioner has been working as a teacher in the Forest Village School. And my lord, again, 4 my lord, this has been working against a vacant post, my lord, sorry, permanent post. That the answering Department basis that it is a fact that the school remained closed since January 94, my lord, after the retirement of Sri Upen Chandra Bora. However, after appointment of Srimati Swapna Pathar Sargyari to the post of teacher on 4/10/2021, the school is functioning currently, my lord. That
But
means once-
who is Swapna Patel?
Swapna, according to the, as per the High Court's order, my lord, the Swapna Patwari has been transferred to that school, my lord. She had also similar problems, my lord. She was in Nagaon, my lord, and she was working against a post as assistant teacher like the petitioner. And after the case is filed, my lord, and the order has been passed by this honorable court, my lord, she has been appointed immediately, my lord, and she has been transferred. Instead of creating a post, my lord, the direction was a post should be created. But since there was a vacant post, and that means the petitioner was not regularized, she has been transferred to that post now.
So she is serving as what? A forest
Yes,
village teacher.
Yes, madam.
That
And
is the
she is the
post
only-
sanction,
Yes, madam, yes.
sanction.
There are
Yes,
two
yes,
posts, there are two schools allowed. One is at Tingrai Forest Village
Tingrai, yeah.
and one is at Rongchongi Forest Village.
Yes.
So in Rongchongi, Swapna Patel has been appointed. Now the Tingrai post is lying vacant, your lordship. The petitioner can join there, your lordship.
Yes, madam. She can be regularized.
Then you regularize her services. But this is not under education department.
It is under forest, madam,
Under forest.
under forest. madam. And principal secretary, principal conservation is the main person, madam. He is the appointing authority, madam.
Since Swapna Patel is already being appointed Rongchongi Forest Village, the Tingrai Forest Village, your lordship, which is another school. The petitioner can join there, your lordship. That was lying vacant.
Take down. Heard Miss M.D. Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. R.R. Gogoi, learned standing counsel Forest Department Assam, appearing for the respondents.
All of them.
All the respondents.
All of them.
Stuff. The read petitioner hearing. Is working as a teacher in the Rongchongi, RONGCHONGI, Rongchongi Forest Village School under Lokkipatha range of Digboy Forest Division under Tinsukia district, full stop. According to the petitioner, she had joined the said school on 01/01/2002 against a sanctioned vacant post and has been serving continuously since then. First up, however, since the services of the petitioner has not been regularized, nor has she been paid regular salary and allowances, the instant writ petition has been filed seeking a writ of mandamus. First up, the respondent number 4, that is the Divisional Forest Officer, Digboy Division, has filed an affidavit practically admitting the claim of the petitioner. First up, Mr. Gogoi, Learned Standing Council, Forest Department, Assam, also submits that on field verification, it was found that the petitioner is regularly working as a teacher in the Rongsangi Forest Village School, and therefore there would be no difficulty for the authorities to regularize her services in the aforesaid post of forest, in the aforesaid post of teacher in the Forest Village School. Full stop. Mr. Gogoi further submits that the petitioner will also be paid her area salary and allowance, if any, payable under the rules for the period of services rendered by her. Full stop. If that be so, this writ petition can be disposed of finally by issuing a writ of mandamus to the authorities. Full stop. As such, this writ petition is hereby disposed of with a direction upon the respondents to consider the case of the petitioner for regularization of her services against the sanctioned vacant post of teacher in the Forest Village School of Rongsangi.
Tingrai. Rongsangi has been filled up. Tingrai is vacant, your lordship.
Tingrai, not Rongsangi. Instead of Rongsangi, you write Tingrai. She is working in Tingrai since
She was working in Rongsangi on the temporary basis. Thereafter, in Rongsangi, Swapna Patgiri was appointed. Now Tingrai post is lying vacant, so petitioner can join their lordship. It's the same Forest Village School. Difference only 2 kilometers, your lordship.
So then, had joined in Rongsangi, you have said that. Then add a sentence here. Mr. Gogoi submits that although the writ petitioner was initially appointed in the Forest Village School at Rongsangi, yet the services of one Sapna Patar Swargadi has been regularized against the post of teacher of Forest Village School Rongsangi. But since there is another vacant post of teacher of Forest Village School at Tingsangi, what is the spelling?
Tingrai.
Tingrai, which is about 2 kilometers away from the Rongsangi school. The case of the petitioner can be considered for regularization of her services in the post of teacher in the Tingrai school. Then it will come. If that be so, so can be disposed. As such, this writ petition is hereby disposed of by directing that the services of the writ petitioner shall be considered for regularization against the vacant sanctioned post of teacher in the Forest Village School at Tingrai. Full stop. Moreover, the petitioner shall also be paid her arrear salary and dues for the period of service already rendered by her. Full stop. The direction issued herein above shall be carried out and completed. Shall be carried out as expeditiously as possible, but not later than
1 month, madam.
why 1 month? Not later than 3 months from the date of receipt of a certified copy. What are the 2 IAs? What are the interlocutory?
These are, madam, that time, madam,
IAs and
disposed of, madam. Okay.
Item 29 is wrongly listed. Item 31.
Lordship, in this case, sometime may be granted to file affidavit, Lordship. As per my instruction, they are verifying the matter.
This is a covered matter, Lordship. In other cases, court dispose of the matter, directing the persons who scored higher marks than the unreserved candidate to select and give service. So I have prepared a third, Lordship, of the petitioners.
Covered case.
Lordship, they are the SSC is verifying the matter, Lordship, whether it is covered or not.
Lordship, it is
Some more time
I heard Mr. R. Sharma, learned counsel for the petitioner, also heard Ms. R. Devi, learned counsel for the CGC, who submits that the process of verification is going on to figure out if this case is covered by the earlier decisions of this court, and therefore 2 weeks further time they granted for her to obtain instruction in the matter. Prayer allowed, list this petition again after 2 weeks. Let her,
Some there may be case, Lord.
after Bihu, fix the date. Yes, list again on 19th of April, 2023.
Obviously.
37 is also similar matter, also. They are also seeing time in this.
37.
Yes, sir.
Same order.
I am making.
You write the name of Mr. S. P. Sharma.
B. Sharma.
Lana CGC. B. Sharma, Lana CGC. Otherwise, same order.
May it please your lordship.
Yes.
Yes, list to compassionate appointment, my lord. Petitioner father died 9/10/99, my lord. Then he applied 24/7/2001, my lord. Lordship kindly turn page.
99.
Yes, but there is a correspondence, my lord. Your lordship kindly turn page 25. Divisional Forest Officer lordships forwarded his name to Conservative of Forest, my lord. But then again, my lord, lordship kindly turn page. Page 37, where it is stated that his case cannot be considered because non-approval of from the government, my lord. That is findings, my lord. Then in the year 2014, my lord, there is a notification, my lord. That in this
Acha,
notification.
Mr. Gogoi, person dying in 1999. Can a writ of mandamus be issued today to
No,
consider?
my lord, because my lord, that very objectable scheme will be defeated, my lord.
So where is the judgment or circular to that effect?
My lord, earlier I approached this honorable court, my lord. This honorable court passed an order. my lord.
This is what goes
Yes.
on.
Yes,
Well,
yes.
These are all,
This is from weak appeal, my lord. Forest Department.
My lord, in the meantime, my lord, 2014, my lord, they have issued one notification and stating inter alia that they will take all the compassionate appointment, considered all the compassionate appointment in the year 1994 to 2014, my lord. So I was approached before this honorable court, my lord, earlier, my lord.
So my lord, this Umesh Nagpal has been reiterated, my lord.
you do it some other time, somewhere else. I'm not allowing this kind of.
Yes, my lord.
On the prayer of Ms. Devi, learned counsel for the petition. This matter stands adjourned for 4 weeks. Mr. D. Gogoi, learned SC, Forest Department, Assam, and Ms. Gogoi, learned Government Advocate, Assam, are present on behalf of the state. Give him the copy of the order.
Yes, my lord.
Have a look at this order.
Yes.
This can't go on like this.
Yes, yes,
It
yes.
cannot.
Yes.
Only if at that point of time, if a mistake is committed and the relief can be granted, that is different. Otherwise, this process will go on.
Yes, yes, my
So,
lord.
you'll find someone dying pre-independence era also now coming. On pensionary
Highly obliged.
99, 94.
Yes, sir. But
Now the petitions are
2014, they issued notice, my lord, that they will take all the compassionate appointment which was left out. That is why I approached this honorable court.
No, no, they can do
That
anything,
too,
but
the honorable
judges-
court's order is there 2005, my lord. That is their lapse, my lord.
all right,
highly obliged.
take a chance.
All right. May it please your lordship, my lord. My lord, here, my lord, as per page 32, my lord, 29/4/2019, my lord. That petitioners were, my lord, given the benefit of regularization, my lord, as per the office memorandum, my lord, 27 June 2013. My lord, the pay scale was there, my lord. pay scale of rupees 12,000 to 37,500, my lord. My lord, that under the one. Under the one-time exercise, my lord, page 21. That is the office memorandum, my lord. This was issued as per the my lord, judgment of Uma Devi as well as my lord ML Kasari case, my lord. Now, while paying this, my lord, this Upenda's case has come up. This Upenda said, my lord, to pay the minimum scale of pay and some concession given by the government. Now, our case is that, my lord, since our case was considered as per the OM, my lord, at page 21, we were engaged against sanctioned vacant post. And this Upenda's case is limited to person engaged in non-sanctioned post, my lord. I have enclosed that my judgment, my lord. Page 29, can you see my para
Who is
22.
appearing for the state?
Lordship, I am appearing.
You are admitting the case.
No, Lordship. So
Then no affidavit has been filed.
affidavit has not yet been filed. Lordship, so far as page 33 is concerned, Lordship, that is not
But
regular.
he wants disposal. We'll
Lordship,
accept that the
if your
state has.
Lordship, the Lordship may dispose of on the, I can argue on the basis of repetition also, Lord. But I pray Lordship will grant me some time to find my affidavit. Because this is not an regularization order.
No.
This was issued in terms of the Upenda's order.
No,
In the
this is- that
Upenda's,
is
it
correct.
has
Incorrect.
Let him say.
My lord.
Have that courtesy, Mr.
Yes,
Das.
Lordship, in the Upenda's Lordship, it has been held that as your services cannot be regularized, government will give you the minimum of the
In
pay
lieu of regulation.
Lordship. So if he is claiming that he is working against a sanctioned vacant post, nowhere it has been annexed. It is merely a statement, Lordship, that I am working against a sanctioned vacant post. Even his appointment letter is not there in the brief petition, Lordship.
So he has to file affidavit.
Yes, my lord, by the last order also, because we shown the sanction number and all para 3, my lord, therefore the honorable court said to filing the affidavit.
Heard Mr. B.K. Das, Nanak, counsel for the petitioner, the writ petitioner's hearing claims to have been appointed against sanctioned vacant post
Yes,
way back in the year 1995. And therefore, they have rendered more than 10 years of continuous service under the government. First of, agree by non-consideration of their cases for regularization of service, the instant writ petition has been filed. First of, Mr. P. Nayak, Learned Standing Counsel, this is for which department? PW Department, Assam, has opposed the prayer in the writ petition. Although the pleaded stand of the department is not available on record. Having regard to the nature of controversy involved in this writ petition and taking note of the request made by Mr. Nayak, 6 weeks further time is granted as last chance to the department to file affidavit. Full stop. Register to list this matter again on 15th of May 2023 as a fixed item. In the meantime, the respondents may file affidavit by serving advance copy upon the petitioner's counsel if so advised.
obligation. My lord, prior, my lord, 10 years prior to my lord, 10/4/2006. Lordship has recorded, my lord, 10 years prior to 10/4/2006.
10 years prior to 10/4/2006.
Obligation.
Yes. And therefore, were entitled to regularization.
This is also regulation, my lord. I am resisting the prayer. And my lord, because very recently, my lord, Supreme Court again has said 2 yardsticks has been fulfilled, my lord. This sanction post and my lord, competent authority. So my lord will be filing an affidavit. So we are resisting the prayer, petitioner seeking regularization, my lord.
They were appointed in 1988 as workers, Khalasi. Later on, they were deputed in the Assam Worker
We'll have it on 15th along with the other matter.
Lordship.
My lord,
Heard Ms. R. Devi, Learned Counsel for the petitioner, also heard Mr. D. Gogoi, Learned Standing
it's
Counsel.
PH.
PHE will submit that affidavit on behalf of the department has already been filed.
No, we'll file, my lord.
They have not filed Lordship.
Who submits that 4 weeks further time be granted to file affidavit on behalf of the department opposing the prayer made in the writ petition. Taking note of the submission made by the Learned Departmental Counsel, 4 weeks further time is granted for filing affidavit. Register to list this matter again on 15th of May 2023 as a fixed item. The respondents may file affidavit by serving copy upon the petitioner's counsel in the meantime.
Last one's
Okay.
lost, because since 2021, they are taking.
Yes, yes,
On 15th, we'll dispose of all matters of regularization. Where affidavit filed, not filed, will not matter.
Item 35.
35 also same, my lord, regularization matter, my lord.
My lord,
Fix it on May 15 May, by that. We,
my lord, this case is covered by the judgment of this honorable court. After the my lord Upendas. And this is case 180. After the my lord Upendas, my lord. Page 80, my lord. And operative part, my lord, page 87.
Page 80.
Page 87, my lord. The operative part, judgment is started, my lord. 87, my lord, para 3, lordship will find.
187.
Sorry, my lord, 187. I am extremely sorry, my lord, 187. The operative part of the judgment. 187, para 3, my lord. Para
187 para 3.
Para 3.
Yes.
Yes. Well, this is the petitioners are serving as tax collectors, so and so, in different concept and Jilla Parishad in the district of Jofat, so and so. The petitioners are agreed by the order dated P so and so, passed by the additional chief secretary of the government of Assam, Panchayat, Rural Development Department, for the cases of some of the petitioners' case were rejected for regularization. Then your lordship kindly see the
Covered under which paragraph?
yes. Now lordship kindly see page 193. Page 193.
Yes.
Yes. Considering the process that taken place in the file number so and so, taking into consideration the grounds taken by the respondent number so and so, impugned order dated 21/11/2015 and 3/12/2015 for rejecting the case of the petitioner for regularization in this course of the concerned opinion that the respondent number 3 had not considered the case of the petitioner in its proper perspective while passing the
So
same.
what is the covered? What is covered means? What do you mean by covered?
Because my lord, the regularization of the petitioner service.
Yes.
Who are
The matter has been remanded back for fresh consideration.
Yes, and ultimately they have been regularized. My lord. We have annexed the order also. My lord.
Where is the order?
That order lordship will find at page, my lord, 225, my lord. 225. Yes.
So there is some contempt case.
Yes, my lord, after that, there was a contempt case, my lord, that has also, my lord, annexed in this, my lord, present petition, that your lordship may see, my lord, the contempt order at page, my lord, 194. Page 194, my lord. In the contempt proceeding, there was an order. And my lord, authority part, my lord, page 200.
So you don't want to file any affidavit.
Affidavit, we are almost drafting, my lord, drafted the affidavit, my lord. So we are scrutinizing the affidavit on the law points, my lord, and thereafter we will send for vetting, my lord. Therefore, some time is required, my lord.
Let him file his affidavit. Hurriedly, these things can't be done.
Yes.
Heard Mr. M. Monal and counsel for the petitioner, also heard Mr. S. Datta, and standing counsel, PNRD Department, Assam, who submits that the affidavit on behalf of the department to be filed in this case is almost ready and will be brought on record within 4 weeks from today. First up, as such, come on the request of Mr. Datta, registry is directed to list this matter again on 10th of May 2023 as a fixed item. Affidavit on behalf of the department, if any, shall be positively filed on or before 28th of April 2023 by serving advance copy upon the Petitioner's counsel. You obtain instruction and then we'll dispose it off.
Item 36.
This petitioner referred to be the peon in the Guwahati Municipal Corporation. He was absent from duty due to his illness from Lordship 15/9/2018 to 6/1/2019. Lordship. Subsequently, on recovery, he submitted an application due to his illness. He could not attend the duties, and therefore he may be allowed to join. And for that period of absence, he also submitted some leave applications. Lordship. Subsequently, the leave application was granted, but the petitioner was not allowed to join. Ultimately, subsequent to the date of submission of his application for joining, that is from 7/1/2019 up to 5/1/2021. The authority, he repeatedly requested the authority to allow him to join. He was not allowed. Subsequently, the petitioner was referred to the medical board. Medical board confirmed that he is fit to join the service. Thereafter, Lordship, the GMC authority initiated departmental proceeding, Lordship, against the petitioner, and that was concluded on 5/1/21, Lordship, and thereby, Lordship, the authority may read it, Lordship. Peruse the reply in respect of disciplinary proceeding drawn against defendants peon, division so and so, white letter number 12. The charges of gross negligence of duties, indiscipline, and insubordination has been admitted by him. In this regard, the defendants peon is hereby allowed to join in his duties with immediate effect, and the period of unauthorized absence from 7/1/2019 to till date, the joining treated as unauthorized leave without pay for all purposes like increment, leave, etc., pension, etc., and the DP case drawn against him is hereby dropped and disposed accordingly. So I'm coming against this order. Lordship.
Which paragraph, which page you said?
The order is at page 57. Lordship.
So what is wrong with this order?
It is not me, Lordship. It is the authority who did not allow to join me, Lordship. After Lordship will find that this is the application on 7/1/2019.
So now he is serving.
He's serving.
So what is the grievance now?
Lordship, cancellation of benefits, Lordship.
Huh?
The benefits which he has been deprived of, Lordship.
What is the benefit?
7/1/2019 up to 5/1/2021, Lordship. Unauthorized leave without pay for all purposes.
7/1/2019 to
19 to the date of passing this order, Lordship. That is 5/1/21.
So this period, how this period has been treated?
this period with this period, he will not get the pay, my lord. Before that, my lord, also will turn to page number so cause, my lord. Page number 54, the so cause of that particular period. And he comes with a reply. Lord will find the reply in page number 56. In the very first paragraph, he admitted there is a mistake. And first paragraph, my lord, with due respect, I have the honor to inform you that the
Page.
page 56.
Hmm.
The charge sheet and the statement of allegation received accordingly, as per charge, which statement of allegation is true, a charge framed against me. He admits that the charges are true. That's why we become lenient, my lord. Thereafter, the order has been passed. He has been instituted in service, only that the period he has remained absent, that period he will not get any pay. There is work with no work, no pay. He has admitted that fact. And the
No,
duty has been
from the content of the document, lordship, it does not amount to admission because he has shown the reason. So informed that I have been availed commuted leave so and so due to illness with effect from 15/9/2018 to 2/6/1/2019. So and so the disease were duly examined and reported by the chairman, State Standing Medical Board and additional director of Health Services Assam. I applied for joining my duties on 7/1/2019. That's it. After recovery of illness on 7/1/2019, but you will find it is a page 32, lordship. This is the application he submitted before the authorities to allow him to join. What the authority has done, the authority has not allowed him to join the service. Instead, he was referred to the medical board. And medical board when given the opinion after that event, he was not allowed to join.
Where is the opinion of the medical board?
Medical board is at lordship page type copies at page 40, lordship, chairman, standing committee medical board.
Page 40.
40, lordship, and originally is at page 42 and 43. Lordship. On the basis of lordship.
Yes, Mr. Bora, why you are not allowed to join duty?
Lordship will turn to my affidavit of position, paragraph number 4. He is an habitual. He is an habitual absentee. He comes with. He doesn't remain present himself. He comes with the application by someone else. He submits it, then he vanishes from the office. It's a habitual absentee.
But then you have to initiate a proceeding against
That's
him.
how the proceeding was initiated, but because he had admitted, he became lenient and said that.
Proceeding was initiated when?
Lordship will turn to pay, show cause notice 54, page number 54. This is dated 12/10/2020. Show cause was issued. Only one charge, Lordship will find the charge in page number 55. He remained absent.
It is during that period, lordship, when I repeatedly approached them. There are 3-4 applications, lordship, to allow me join. That was refused. I was
then the reply
sent to medical board. Medical on pursuance to the medical board lordship report. That earlier leave period was regularized. Even then, they have not allowed to join him. Now, again, they have initiated the proceeding. On one hand, they are not allowing to join me. On the other hand, they are initiating proceedings for that period. Absent is on with effect from 7/1. My application has page 32. This is on 7/1. I have submitted.
No, this is one issue which cropped up a little earlier. You see, before you initiate a departmental proceeding under the Assam Disciplinary Service Rules, is there no requirement to issue a show cause notice?
Yes, we have issued so called notice. My lord.
Then he has replied,
He has replied, admitting the fact.
yes.
Then only that the DP has been dropped. Only thing is that what the post the
No, that's what I'm saying. DP is initiated when a charge memo is submitted.
submitted.
But before deciding whether a DP should be initiated or not, is there no requirement to ask the employee to explain his conduct?
Explaining, he has replied it, my lord, in page number 56 meeting.
Please understand the
Yes.
query. Otherwise, in a state of confusion, we don't want orders to be passed.
Lordship.
The disciplinary authority feels that an employee is guilty of misconduct.
Yes.
Therefore, before taking a decision whether he should be subjected to a disciplinary proceeding,
Lordship.
is it not necessary to hear the version of the employee first, what explanation he has to give? In doing so, do you say that why this penalty should not be imposed on you? Penalty is a matter of disciplinary proceeding. This is not a, this cannot be a part of a process when the employer is trying to get the version of the employee, what has happened, to take a decision whether this is a matter where a DP should be drawn or not. So even before deciding whether a DP should be drawn, you are asking why a penalty should not be imposed. That means what? You are convinced that he is guilty.
That may be.
Then what is the purpose of issuing a show cause notice? Some cooperation department matter in the morning, the same thing I have noticed.
The PMT mind, that may be.
What is the position? Tell me. Otherwise, straight away a DP is being drawn without asking the employee what is his problem.
Well, like that.
There has to be some explanation from him. If you are not satisfied with the explanation,
Then
you can go for a DP. But even before that stage, you are asking why penalty should not be imposed. Is this in accordance with the
well, I
disciplinary
will
appeal
examine the law, my lord. In fact, privacy is things that they have already made up the mind, my lord.
then how these processes can be sustained?
So I'll get lots will fix it in other, I will examine the law, my lord. What is there?
No, fix will do,
Lordship,
etc. will
I
do,
have
but at
understood,
least
I have understood, my lord.
people should apply their mind on what they're doing, huh? They should apply their mind. The rules have clear compartments. The employer always has a right to take action, but these are provisions in the rules to comply with the principles of natural justice.
Okay.
Without even knowing what is his answer, you are threatening him why a major penalty should not be. That penalty, question of penalty will come when you are convinced that he is guilty of misconduct. I don't understand what is happening. Similar type of prototype orders are coming from other departments. Either you give an answer explaining why it has happened, or else the court will have to presume that your officers are not conversant with the requirement of the basic requirement of law.
Only so called
Everything is done in a mechanical manner. Then we'll ask them to be subjected to some training. Because you see, all this has a relevance today. These misconceived actions are generating litigations. Litigations are coming to the court. People are subjected to court process, harassment, other facets. Why?
Though this fact is not a his pleaded case, my lord. This is not his pleaded case, my lord.
No, pleaded case, it will not be.
Yes.
Pleaded case, forget it. But as judges, we have a
Yes.
responsibility.
I have seen, my lord.
We have to do what is correct.
Yes, sir.
He is not pleaded case, does it mean we'll close our eyes to what is the reality? Heard Mr. U. Dr. Leonard Counsel for the lead petitioner, also heard Mr. S. Bora Leonard SC GMC, as well as Mr. T.C. Chutia Leonard Additional Senior Government Advocate Assam, appearing for the state respondents. After considering the issue raised in the lead petition at some length, Mr. Bora has sought posting of this matter again on 28/3/2023. so as to enable him to obtain instruction on the query made by this court. List accordingly.
Obliged.
Item 38 and 39.
May proceed. I may refer affidavit in opposition filed by the respondent number 4 in page number 42-47.
So there is a query made by the honorable court in the order dated 15/12. But in fact, Lordship wanted to know what are the post, how the post of Anganwadi helper will be taken for giving them promotion. In fact, I have received the instructions below. But the guideline which covers this matters. This is important, Lordship. I'm touching this guideline,
Yes.
Look, in the writ petition, the things has not been projected correctly. That is why the confusion has been created. Lordship, I kindly take up the guidelines. Kindly come to serial number 8 and 9 for the time being. The promotion shall be made against the vacancies of Anganwadi worker in the existing Anganwadi centers duly sanctioned. 9 is promotion shall remain confined to the Anganwadi centers of the same revenue village. And as such, the Anganwadi helper of one revenue village or ward of a municipality or town committee cannot apply for promotion in the post that arises in the center falling in a different revenue village or ward of a municipality or town committee. Look, what happens, the Anganwadi worker and helper in every center, there are one Anganwadi helper, one worker. And the helper has to be a local resident of that particular center. Center is having a jurisdiction of the survey area. In a particular revenue village, there may be 3, 4, 5 revenue Anganwadi center in a revenue village. But the person, actually this Anganwadi helpers and workers, they are not holding any public post. They are under the scheme. Since they are working, helpers are working for a period of 10 years. The government has formulated this particular scheme so that if some vacancy arose in a Anganwadi worker post, they may be given an opportunity to upgrade themselves. That is the whole idea. So if 4 Anganwadi centers are there in a revenue village, the Anganwadi helpers of that 4 center can participate in a process for upgradation in a particular Anganwadi worker post. If some Anganwadi worker post fell vacant
Within the same revenue village.
within the same revenue village. Here in this writ petition, the projection has been made that the honorable court passed an order directing the respondent authorities to consider their application. That has not been done. Without doing that, now some posts have been advertised falling under different revenue village. That is what the projection is. So they are not at all liable to be entitled to be considered for this post advertised, because those are admittedly fall under different revenue village. And secondly, the posts which were advertised and challenged by them, and those are under different revenue village, those are till date, my instruction says, till date, that has not been filled up. Whenever those are filled up, my written instruction says that their application will be considered.
May I plead with Lordship?
Have you seen the circular?
No, my lord.
Then you have a look at the circular and then come back.
Yes, ma'am.
Otherwise, how can you?
My lord.
And I have also given the decision of the Honorable Apex Court. There, the things have been clarified. The kindly, just for a moment, the facts are important, but kindly come to para 20. Worker and what is the position of the worker and helper under the Anganwadi? In this case, they were claiming minimum wages.
Anganwadi workers, however, do not carry on any function of the state. They do not hold any post under a statute. Their posts are not created. Recruitment rules ordinarily applicable to the employees of the state are not applicable in their case. State is not required to comply with the constitutional scheme of equality as admitted under Article 14 and 16 of the Constitution of India. No process of selection for the purpose of their appointment within the constitutional scheme exists. We do not think that the state decision has any application because that Mojadars are public servant, that was the issue. Then kindly see, Malad, there are 28, Malad. However, the rules framed under proviso to Article 309 of the Constitution of India are not attracted. In the case of the respondents, they are the Anganwadi workers. They are appointed under a scheme which is not of a permanent nature, although might have continued for a long time. Appointments made under a scheme and recruitment process next para being carried out through a committee, in our opinion, would not render incumbents thereof holders of a civil post. Our attention has not been drawn to any rules or regulation governing the mode of their recruitment. Some statements in this behalf have been made by the interveners, but for the reasons stated herein before, we cannot enter thereinto. A distinction must be made about a post created by the central government or by the state government in exercise of their power under Article 77 or 162 of the Constitution of India or under a statute vis-a-vis cases of this nature, which are sui generis. Terms and conditions of service of an employee may be referable to acts of appropriate legislature. The matter may also come within the purview of Article 309 of the Constitution of India as proviso appended thereto, confer power upon the president or the governor of the state or other authority who may be delegated with such power to make rules during the interim. 31. One of the questions which raised before us was in regard to the right of an Anganwadi worker to contest an election. They are indisputably free to do so. A holder of a civil post may not be entitled thereto. So the nature of the post held by them is they are not holding a statutory post, a civil post. But in fact, they are serving under a particular scheme, and therefore the case projected by the petitioner that they should be promoted against the post of Anganwadi worker after completion of a particular 10 years of period. It is absolutely incorrect.
Before the cases may be disposed of today because this advertise was done 24/12/2019, and later also address was declared by the some respondent number 4. In this second advertisement, our center were not advertised, but mentioned by the respondent number 4 in affidavit in opposition, para number 13. I may refer to lost it. Yeah, the respondent number 4 mentioned about why she did not advise, did not mention our name. Para 13 in affidavit in opposition, I by the respondent number 4.
Advertisement dated 24/12/2019 pertains to posts of
Anganwadi centers under which their centers, the revenue villages under which their centers are there. So they are entitled to be considered for those centers. Pursuant to the 2019 centers, no selection process has been done because of this litigation and all these things. Whenever it is started, subject to their eligibility, they will be considered. But now the advertisement at page NHR 8, page 34. They have in the translated copy, they have not typed properly. These are 36 is the vernacular. Revenue villages are different. These are not. It is in fact admitted by the petitioner also. These are from different revenue villages. So they cannot claim upgradation. In fact, there is no concept of promotion.
So as and when posts of Anganwadi workers in the revenue villages in respect to which the petitioners are working
Logic.
is taken up for
subject to their eligibility as per the guidelines, they'll be considered.
My lord, in
There is no-
second advertisement, we have, our name was not, we are mentioned, but mentioned in para 13 in evidence opposition filed by the Revenue Authority that as the litigation is standing in Guwahati High Court, for this reason, I cannot mention that means Revenue Court did not mention our name, they mentioned here clear and written by her. Para 13.
All right, heard Mr. So-and-so learned counsel for the writ petitioner, also heard Mr. D. Nath learned senior government advocate Assam appearing for the respondents full stop. The writ petitioners herein claim to be working as Anganwadi helper under the, which is the Anganwadi center under the
Anganwadi Center, my lord.
Their center is number 31, Goremari, Uttar
under
Moitto 5.
number 231, 231,
Number 231.
231, Goremari, Gaon, Uttar Madhya,
5
Anganwadi
Anganwadi
center.
5 Anganwadi center.
Another petitioner also.
And another is 96 number Daptokusi 1 Anganwadi center.
So then you write, the petitioners are working as Anganwadi helpers. Full stop. The petitioner number 1 is serving under the 231 number Goremari, you'll get in para 2. Uttar Madhya Anganwadi Center and was appointed on 23/12/2009, whereas the petitioner number 2 is was transferred to the said Anganwadi Center and posted. No, that is the
96 number.
petitioner number 2 was posted as an Anganwadi helper under 96 number Dattakuchi 1 Anganwadi Center, para 4 you will get it. By selection dated 12/11/2009. Full stop. According to the petitioners, they are eligible for being considered for promotion stroke
It
upgradation
is upgraded.
to the post of Anganwadi worker. Full stop. However, the respondents have not considered their cases for upgradation. Full stop. It is also the case of the petitioner that by issuing advertisement notice dated 17/11/2021, the respondents are proposing to fill up all the posts of Anganwadi workers without considering the petitioner's claim for upgradation to the post of Anganwadi worker. Full stop. On instruction obtained by Mr. Nath, he submits that the petitioners are not holding any public office, but the posts of Anganwadi helper public worker are created under a scheme. Full stop. Therefore, the question of promotion would not ordinarily arise. However, full stop. However, the Anganwadi helpers can be upgraded as Anganwadi workers subject to fulfilling the requirements of the government notification dated 4/3/2013, which lays down the guidelines for doing so. Full stop. According to Mr. Nath, the petitioner's case can be, petitioner's plural, case can be considered for appointment oblique upgradation as Anganwadi workers in respect of any of the Anganwadi centers falling within the same revenue village. Therefore, full
Where
stop.
they are serving, bro. Where they are serving.
The same revenue village where they are serving. Full stop. Since the advertisement notice dated 17/11/2021 pertaining to Anganwadi centers which are outside the revenue village where the petitioners are serving, they cannot claim any right in respect of any of the in respect of any of those Anganwadi centers. Full stop. Mr.
My lord, I may refer to
No, I asked you whether you want, now I'm not going to hear you. That's all.
earlier advertisement, my lord.
Mr. Aklas, when it counsel for the writ petitioner has not disputed the proposition of Mr. Nath made on the basis of the notification dated 4/3/2013. First up, if that be so, rest of the contentions of the parties of the petitioner's counsel would be irrelevant in this case. First of all, having regard to the facts and circumstances of the case, this writ petition is being disposed of by providing that as and when posts of Anganwadi workers are filled up in the Anganwadi centers coming within the revenue village, which is a revenue village.
My lord,
Well, their revenue village will be the one Dottokusi revenue village
and
and Garamari Gaon revenue village.
Dattagiri revenue village and Goramnigao revenue village. The cases of the petitioners would be considered in accordance with the guidelines laid down in notification dated 4/3/2023. With the above observation, writ petition stands disposed of. Yes, I asked you whether you want to examine the
It is
Right.
4/3/2013.
4/3/2013.
my lord, they are working on the same center where posts are lying again.
All right, they will be
Whenever-
considered now,
Whenever process is initiated.
whenever the process is initiated,
Yes.
as and when the process is
Not-
initiated.
Item 14.
May I please, your lordship. Lordship, this matter pertains to subsequent alteration of date of birth, lordship. On the earlier date,
For last court order, your lordship that asked for a case law, which was decided by your lordship, by honorable chief justice and your lordship. This is the-
Consumer Khatun,
Have you seen it?
I have seen. It is covered in my case, lordship.
Covered by which paragraph?
Paragraph 14. Otherwise also.
All right, then we'll dispose it of. Take down. Heard Mr. H. Talukdar, learned counsel for the petitioner. The petitioner was appointment as a handyman under the respondent number 5, wide order dated 30/4/2007. And since then, he is serving under the respondent department. Full stop. The age of the petitioner recorded in the service book. No. Wait a minute.
Findings are recorded on 23/2/2023, lordship. Court order, lordship. 23/2.
No, you're right. As per the transfer certificate issued by the school where the petitioner had studied, his date of birth has been mentioned as 28/01/1971. However, in the and the said fact is also mentioned in the identity card issued to the petitioner. Full stop. However, subsequently, the petitioner's date of birth was wrongly recorded as 10/2/1963 in the registration form of NPS account. And the petitioner, without being aware of the aforesaid mistake, has signed the form. Full stop. In doing so, the date of birth of the petitioner recorded in his PAN card was taken into account. Full stop. Full stop. Although the petitioner had requested for correction of his date of birth in the service book, the authorities did not consider such request made by the petitioner, as a result of which he was made to retire from service on attaining the age of superannuation with effect from 28 to 2023. First step. After hearing the submissions made by learned counsel for both the sides, it appears that there were two sets of documents available before the authorities pertaining to the writ petitioner, wherein two different date of birth of the petitioner has been reflected. Full stop. The question that would, therefore, arise is as to whether which of the two conflicting date of birth is required to be acted upon. Full stop. In other words, which is the document which is to be given precedence for except for recording the date of birth of the candidate when contrary materials are available. Full stop. The aforesaid issue has been answered by the division bench of this court by the order dated 20th February 2023, passed in WPC number 6858 of 2022, bracket Anjuma Khatun versus State of Assam and others. The relevant observations made in para 14 of the said decision are quoted herein below for ready reference. Report para 14. First up. In view of the law laid down in the efforts in the case of Anjuma Khatun Supra, it is now established that the authorities will have to act on the certificate, the school certificate or the matriculation certificate of the petitioner while recording considering his actual date of birth. First up. This writ petition is therefore disposed of by directing that the petitioner would submit his school certificate, matriculation certificate before the authorities within 7 days from today, along with a certified copy of this order. If the said certificate, if the authentic copy of such certificate is produced by the petitioner before the respondent number.
Respondent number 4.
Respondent number 4.
4 and 5, Lordship.
Respondent number 4. Within the prescribed period, necessary steps for redressal of the grievance of the petitioner shall be initiated as expeditiously as possible, but not later than 4 weeks thereafter, by following the due process of law. The petition stands closed. Yes.
I may be reinstated if I am released from service.
Or everything they will consider. That's redress of grievance.
I think application should be prepared before the executive engineer. He's my DDO, Lordship.
No, he doesn't have the power to give you the relief. You take your seat. Yes.
Deeply.
Very much.
My lord.
My lord, the petitioner is working as a grateful employee, my lord.
Yes. I am praying for some time to file my affidavit in opposition because my petitioner, that is respondent number 4, he is in very bad shape. He is undergoing treatment in GMC. He is to undergo an operation today. Because of his prolonged treatment, I could not file it. So I may be given some time, my lord.
So far as the affidavit of department is concerned, we will be able to file it by tomorrow.
Notice of motion was issued on last year, April 8, my lord, almost 1 year back.
What is this matter about?
My lord, the relevant rules prescribe graduation and promotion from the grade 4 to junior assistant, that is the earlier post. Now the private respondent number 4 and 5, who are not admittedly not graduate, my lord, they have been promoted, but not by, while I am graduate, no promotion has been granted to me, my lord.
What is your stand? You file affidavit.
No, we have not filed, we will be filing it by tomorrow. Copy I can serve him today itself, my lord, so far our stand is concerned.
After 2 weeks, we'll have it. Heard Mr. J. Patwari, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned standing counsel, finance department, Assam, appearing for the respondent numbers 1, 2, and 3, who submits that the affidavit on behalf of the department will be filed within 2 days, and therefore this matter be adjourned. Similar the stand of Mr. So-and-so, learned counsel for respondent number 4, who submits that his client is Mr. Nandi, who submits that his client is undergoing medical, his client is hospitalized, and therefore some time is required to file affidavit. In view of the submission made by respondents counsel, this matter is directed to be posted again after 3 weeks. In the meantime, the respondents may bring their stand by filing affidavit after serving advance copy of the petitioner's counsel. Yes.
Deeply.
May I please your lordship? Lordship, on last occasion, respondent counsel was supposed to file affidavit, but they have not filed.
Who is for the department?
PWD, lordship.
PWD standing counsel.
42.
Hmm.
So he will give us some time to file affidavit, my lord.
Some more time. Ms. B.V. Hussain, learned counsel for the petitioner is present. Mr. B. Gogoi, learned SC PWD question is granted 4 weeks further time to obtain and file affidavit. List the matter accordingly.
Item
Yes.
43.
Much of it.
May I please, your-
Hmm.
may I please, your lordship? Matter related to regularization of charging.
Hmm.
Your lordship, this case is covered by case.
Is it covered? Huh?
Earlier two occasions, this court has rejected his prayer.
No,
So
your
the
lordship.
petition is barred by resolution.
So we'll take it up at 2. You come.
Item 44.
Lordship, I have received some inspection, lordship. One petition is pending in which the petitioner number 2 and 3 are party, that is 209021. I don't think so that has been stated or not. And one more thing, lordship, yeah, the nodal agency was the CRPF. They have to be added as a party, the lordship, because the physical efficiency test.
Technicality, my lord, the recruitment is for all the armed forces, police forces.
They were the nodal agency, they conducted the physical efficiency test and the physical standard test, lordship.
My lord has already disposed of umpteen matters, my lord.
And the
The issue-
petition number
issue is-
2090 is pending, lordship.
Issue is whether they could, when the reserve category
And when to
candidates
fill a
have
detailed
secured
affidavit.
more marks than the candidates under the unreserved category, they should not be deprived of the appointment. my lord.
But
That's
is
a-
there not some delay in filing this?
There's absolutely no, my lord, my case is squarely covered by your lordship's judgment, my lord. There are a number of judgments on the same point, my lord.
That's
where-
correct. But why have you come now? Why in
My lord,
2023? This recruitment process pertains to 2018.
True, my lord, I have filed the application as soon as possible, my lord.
Mr. Srinivasan, the problem is this court has already declined relief in similar matter on the ground of delay. Therefore, it is difficult.
My lord,
I think
my lord,
now they can't do it because the posts have been filled up. You have waited so long.
my lord will non-suit me on the ground of delay. My lord.
Of course, otherwise these are becoming
My lord,
never
there's
ending
absolutely
business.
no delay, my lord. As
We
soon as
have compassionate appointment applications where persons died in 1994. They are still coming.
My lord, where is the delay, my lord? My lord, learned friend is just making an
No,
omnibus.
when was your application rejected?
My application, as soon as the select list was published,
When?
the select list was published, my lord.
21/1/21.
What?
21/1/21.
What is the connected matter about?
Yes, filed a there's two of the petitioners filed a writ petition along with others that is pending 2090/2021.
2090.
Oh,
2021.
Are you aware of it, Mr.?
no, my lord, no, my lord. I don't have any instructions, my lord. There are 4 of them. Four of the petitions are there for your lordship.
Let us have a look at what is there. Mr. Chief, and Council petitioner is present, Mr. Each authority prepared for this. On the request of the CGC, this matter is directed to be listed again in the next week. Along with WPC number 2090/2021.
We had come to the court in January. We had approached the court in January.
No, this is 2023.
Anyway, we'll see, let's see what is that in the other.
My lord.
Standing
All right.
matter.
All right, we'll rest of the matters at two. At two.
$19, my lord. New incumbents have joined, they have put to notice, my lord, I'll seek some time whether I have to take instruction whether this has been complied or not.
None appears for the petitioner, Mr. D. Gogoi, learned counsel appearing to the respondent submits that he be granted some time to obtain instruction as to whether the order of this court has already been complied with or not. In view of the request made by Mr. Gogoi, this matter stands adjourned for 4 weeks.
Item 46.
Service report it everything. I'll take first step, my lord. 2-3 times they have not.
First steps on whom?
On respondent number 1, my lord.
Mr. B. Chakravarti, learned counsel for the petitioner, prays for any granted liberty to take fresh steps for service of notice upon the sole respondent by registered post. Steps be taken within a week from today, making the notice returnable in 4 weeks.
Item 47.
My lord, this is regarding my lord payment of revised pay scale. My lord, person has been retired, my lord. Due to non-payment of this revised scale, my lord, he's been deprived of, my lord. He could not even proceed with the pensionary benefit, my lord. They're hanging on, my lord. They're holding on my thing, my lord.
Which order has been violated?
My lord. My lord, at page, my lord.
My lord, before
My
that,
lord,
I
page
just let me point out
18,
one-
my lord, 18.
One minute, one technical thing. The respondent number 1, I'm representing the principal secretary. He was not a part in the writ petition. So, my lord, the respondent 1 is not a part in the writ petition, my lord.
That's right, but is he the person to comply with the court order?
No, because in the writ petition, his name was not there. It is the
How
commissioner
does it
secretary, but it's the principal secretary now. There is one technical thing I'm saying. Because
Whoever is to comply with court order must comply with.
no, normally what system, judicial system we follow. With the person who is in the writ petition, my lord, parties, normally we make them parties so that they
So
can comply.
what are you suggesting, that we close the contempt case?
No,
and
not at all,
ask them to find them?
not that, might. I'm not, this pity I'm not going. Just technically I'm saying that the defect is there, my lord. Yes,
This cat and mouse game in contempt cases go on. Everybody retires in 6 months, 8 months, 1 year, the officers think. How much can we ask the contempt petitioners to chase them?
Now, okay, what
They want the order of the court to be complied with, that's all. If there is a real technical difficulty that somebody cannot get into this, he has no role to play, then the matter is different. Otherwise, every officer should comply with the court order. So I am asking you, what is the order? Which is the order?
Order 18, my lord. Sorry, page 18, my lord.
Page 18.
Order dated 4/3/21. Within 3 months, my lord. And I have filed several minor representation.
No, what is that you exactly want?
My lord.
What is that you want?
My lord, my revisional, my lord, revised pay scale should be paid, my lord. And that cross bar, sorry, efficiency cross bar, my lord, even that also has not been issued, my lord.
No, but
And I've been
first,
already retired, my lord.
first of all, there has to be a determination from the court
Yes,
that
ma'am.
you are entitled to X pay scale.
Yes, ma'am.
Where is the determination?
My lord, that is 7 pay scale, my lord, 6 pay scale, my lord.
Where is the determination in the court order?
My lord, it is in last, my
The
lord.
learned judge simply says that treat the writ petition as an application and give him
And my
revised
lord,
pay scale.
last para, my lord.
Yes,
In the last para.
yes.
I have considered both the submissions of the learned counsel, the nature of the grievances as expressed in the writ petition and facts and circumstances leading to the filing of this writ petition. Revision of pay is an entitlement of government servant as and when new ROP comes, my lord. Therefore, the respondents are directed to treat the writ petition itself as a representation and consider the grievances expressed therein and worked out the required steps for granting the prayer therein permissible under the rules.
So therefore, the court has not granted any relief to your client. Let's admit facts which are to be admitted. The court by this order has not granted any relief to your client. The court has merely asked the which respondent?
My lord, that is the respondent number, my lord. All the respondents, my lord.
All the respondents
Yes,
are to take the writ petition as the representation
Yes, my lord.
and grant the prayer.
Yes, my lord. Consider the prayers of my
So
lord.
what is your grievance now?
My grievances was, my lord, for,
No, now what is your grievance?
my lord, they should, my lord, release my revised pay scale, my lord.
Sorry, no such direction is there. No such direction. These are
Because,
matters.
my lord, writ petition has to be treated as a representation, my lord.
That's only, consider your representation, that's all. You can only say that the representation has not been considered, nothing beyond that. There is no direction to grant you any pay scale. There is no determination, no direction, nothing.
My lord, the entitlement is there, my lord, that what is there.
Where is it?
My lord, the revision of pay is an entitlement of
That
government.
is a
service.
general omnibus statement.
That's right, my lord.
Salary is an entitlement of every person working. Does it mean this observation will mean X,
Otherwise,
Y?
my lord, isn't he entitled to get his revised pay scale, my lord?
We don't know. Why didn't you ask that point before the
My lord,
learned
he
judge?
has been working, my lord, and he has retired in 2021, my
See,
lord.
the problem is orders which cannot be complied with or creates unnecessary disruption in compliance is only generating contempt cases, which are also pending for years after year. Today, what is the contempt? You will not be able to answer the questions of the court. Number one, there is no determination here. Number two, there is no mandamus in this case. Number two, the only direction is to consider your grievance. That's all. So you are
But
alleging
that
that
has also not been considered.
only
my lord.
that much we can see. But there is no direction to give you the revised pay scale. Unfortunately, that's the reality. And as judges, we'll have to go by what is there in black and
My
white.
lord, there's nothing open for me, my lord, to get my relief, my lord. There's nothing open to me unless, my lord, they consider my representation as my grievances, as my lord, to release my revised pay scale and to go ahead with the pensionary benefit, my lord. That process has been also stopped, my lord. Cross-bar, efficiency cross-bar is also not issued, whereas, my lord, the government employee who serves for 5 years, they get, my lord, and I have a, my lord, even my lord's record, my lord, that should be passed in my favor.
You may say whatever you think is appropriate.
Up to your lordship, my
The
lord.
point is,
Yeah.
we have to administer justice in accordance with law.
Yeah,
It's not your fault.
Yes, my lord.
But the problem is, they can just reject your prayer and
Yes,
you have to come back to the court again.
my lord,
You agree,
as a
we
lordship,
agree with that. Yes, Mr. Nath.
representation may
My
be
lord.
considered, my lord.
My lord,
That has not
My-
been considered.
the today's instruction at least, my lord, that actually he was involved in a police case, 72 lakhs misappropriation. So he was paid suspension,
No,
the
my
police
lord.
case, my record says so. And the police, FIR was filed, police case going on, my lord. Now the department written to the police also, what's the status? This is one thing. I also find, since he's retired, they're giving him provisional pension, my lord. And also GIS.
Not really.
AG, we have to put the AG, my lord. Next part is the AG, my lord. This is the document within the AG.
Please don't put the paper on the microphone.
Oh,
Hey, we will get these microphones changed, those types there. Ask them to replace it.
And also for GPF, my lord, the efficiency part crossing, that also department has taken steps
Understand now, there is a direction from the court
for consideration.
to consider this writ petition as a representation and pass an order. Has the respondent passed that order or not?
My lord, that is, doesn't reflect, let me get instruction on that particular point, because
Now you want to get instruction? That is the only direction.
Second, yes, but I find the instruction, like they've given him provisional pension, the GIS. all
That
these
we are
things.
not
Yes.
concerned.
Then
That's
they
not
put
the
in the disposal order. I'll ask them, my lord, to find pass an order.
What I am saying is, when you get an order for your client,
Yes, madam.
perhaps it has to be indicated to the learned judge what exactly is the relief that you are claiming.
Yes.
Just getting an order of disposal of representation
Yes,
is not taking anybody anywhere. Again, the contempt is coming, they're disposing it, then the writ is coming. So 2-3 proceedings happening where people are not going anywhere.
yes, madam.
I'm just flagging a concern.
Yes, madam.
I may be open to correcting my ideas.
Yes.
See, 4th round, 5th round compassionate appointments are coming now. 1999, somebody died.
Yes,
So all I'm saying is these orders are not serving any purpose to the litigant, at least. They are going round and round and round.
yes, madam.
You claimed benefit of revised pay scale.
Yes,
If there was a decision that you are entitled to,
yes,
it would have been much easier for this court to pursue that order. There is no such decision. So you know where it is heading.
yes, madam.
You know.
Because that was not my fault, my lord. I have been repeatedly asking them to revise my scale, my lord. But they did not do it because the criminal cases.
All right.
And after the criminal cases filed, my lord, he has been reinstated, my lord, after 9 years. How unfair, my lord. He was suspended for 9 years, then
Mrs.
only we
M. Chaudhary,
approved.
learned counsel for the petitioner, also heard Mr. M. Nath, learned senior counsel, assisted by Mr. Aburijanji, appearing for respond number
One, my.
one, who prays for posting this matter again on 29th of March 2023. So as to obtain instruction and appraise this court as to what action has been taken by the concerned official for compliance of this court's order. List the matter accordingly. Mr. Nath,
Yes,
if the
I'll get
order
it.
is not complied,
Yes, yes.
your officer is coming to the court.
Yes.
My lord, that may be, I think, my lord, that may be also observation may be made, my lord. He has stated that he has also submitted that cross efficiency bars for that, my lord. They have already taken steps, my lord. But which is, I am not, my lord, I am not,
No, he's a senior counsel. He's not going to
that's what, my lord, that
resign on it.
if that is there, my lord. That is, if that is there, my lord, then thing will be easier, my lord. I think so, my lord.
It is
Without
not
that-
difficult even now. Chaudhary will handle it.
Yeah.
We'll handle it.
Okay, my lord.
We'll handle it. But all I am saying is,
Yes, I could understand.
if there are clear adjudications in the order,
Yes.
then the future course of actions becomes faster and more effective. That's all I'm saying. Nothing else.
Okay,
Yes.
all right, fine.
May please. My lord, that day, with regard to an LIC employee not granting house loan jointly applied, Lordship may see the last order passed by your lordship.
Yes, what is the instruction?
Instruction, my lord, I am giving you. Sir.
It's a funny letter I have been served. Day before yesterday, lordship passed an order. Then
My lord,
very next day, I went to office, I was handed down with a, my lord, letter. Let me produce, my lord, this is the letter. Circumventing even in other way around, it mentions about circulars. Lordship may kindly see your lordship's order first. What your lordship said, let me finish. Lordship's order, it is made clear. Lordship found fault with the language used in the first letter. Language in the communication, which your lordship will find at page 15 of the IA, page 15. The letter was at page 15. As your lordship got it.
Yes.
The language your lordship found fault with, and lordship actually that they said that let that man be here. Then I said, may not be, because I don't gain anything by that. Then lordship passed an order. It is made clear that pendency of this IR shall not constitute a bar for the authorities to consider the request made by the applicant for granting NOC for disbursement of house loan. That was order on 28th. The very next day I went. At 11 o'clock, I was handed at my office a peculiar letter, my lord, which let me produce it before your lordship there. Lordship, I think lordship has got it. Now,
You're referring to this one.
no, that is the circular.
It is the circular, my lord.
That is circular. I'll come one by one.
All right.
Let us not be confused. It's not a long matter. I will also produce the circular. This is the letter which has been given to me yesterday. It says, this is to inform you that as per CO circular dated 9/4/19 and CO circular reference number dated 3/1/11/16, the competent authority has decided that it will not be possible to issue an NOC of house loan as your case is to be taken by unconcluded action initiated case as per clause 2 and 2 of 3/11/2016 circular. Now come to the 3/11/2016 circular. Let me produce it. 3/11. Have a look at. Kindly have a look at what 3/11/16 circular says. It is the 3/11/16 circular. Reference is invited to our circular number 95/15, the earlier one, wherein instructions were issued laying down procedure to be followed while issuing NOC for purpose of obtaining passport and visa. It is a case for house loan. Then again, paragraph 1. Employees apply for NOC for corporation as employer for various reasons such as passport, visa, SF loan, education loan, PF withdrawal, etc. Skip this. In respect of passport alone, identity come no objection certificate is issued as per guidelines of Government of India, Ministry of External Affairs. So this is not relevant. It is clarified that Executive Director shall issue. Clause 2. They are telling about clause 2. No objection certificate shall not be issued in a case where vigilance angle is pending against an employee in case so-and-so, prima facie involvement, financial or other perpetrator fraud on corporation committed doesn't apply to me. 2. Adverse view should be taken, unconcluded action initiated. They are mentioning this. That is where charge sheet has already been issued, contemplated cases and also suspension cases, it doesn't apply to me. 3rd, where there is a minor misconduct not involving financial angle or employees involved in a cluster of cases, his involvement is to the extent of contributory negligence, then company to allow NOC and IC while taking into action nature gravity of misconduct related to the company. Then, my lord, they are citing clause Roman 4. Why they are refusing the loan? There may be cases involving our employees which are pending with CBI or other legal authorities. In such cases, decision may be taken by the competent authority in the matter of granting NOC based on the views of such authorities. However, obtaining views from such authorities should remain the responsibility of the concerned employee. That's why, my lord, by the earlier letter, I think I was asked that you go to the High Court and take an opinion from the judge, which your lordship already point forward with. In all other cases, NOC IC. Other requirements as called for by OS department, I think. So, when this circular.
Now, what I'm saying is, all right, they have applied their mind and declined the NOC. Now it is called for the court to either issue a direction or to reject it.
Yes.
So why don't you bring this on record? We'll hear it and pass, give our verdict. It should be a sin.
I believe, now I believe, kindly have a look at the earlier letter. They withdrew. The letter, the wording, my lord, contents and wordings, your lordship found fault with, they withdrew. And then they issued this letter. Now my problem is, I have already paid 5 lakhs rupees advance to the, my lord, real estate owner for a flat. And they are giving me, my lord, notice for making further payment, otherwise my allotment of that particular apartment will be cancelled. I will say that in my petition. Therefore, my
No,
lord,
what I am saying is, this, certainly this matter would have to be dealt with by the court, but we can't do it unless this
No,
these
Lord,
orders are brought.
I think, my lord, lordship can put these circulars and these letters on record and then can pass an order today itself. And I think this is a fit case. Now, today I said, that day I said, I don't want to derive any sadistic pleasure, but the presence of the officer, but that officer should be here. Today I am saying,
No, is there any difficulty in filing a short?
no difficulty, it can be filed.
Why don't you file it? Then we'll follow the process and pass an order.
Lordship may keep
At
that on record
the
also.
most, it will take 1 more week.
No,
Here
no,
they-
let it come on Monday next month. Tomorrow I am filing an affidavit by annexing all this. That's fine. They are. Apparently, after day after.
This is the NOC is on 2 counts. One is if she was to avail a loan from LIC itself. That is one aspect. Do you have any objection if she wants to avail loan from any other organization?
No, this is with regard to the housing finance loan of the LIC.
Okay.
Yeah, my lord.
And this
LIC
circular,
gives the money.
this
Not from
circular,
any other bank. It is not that LIC gets it from any other bank or financial institution. That LIC has its own fund. Give it.
No, I followed. I'm asking, this is one part of it. We'll deal with it. But she also has the option of availing loan from.
Why should I go, my lord?
No, that's another matter. I'm saying that option is there. In that case, is it necessary to obtain NOC from LIC?
It is required, my lord.
Then also it is required.
LIC's own, my lord, condition. LIC's own condition. And every employee, as a routine matter, my lord, they give loan. Because I am asking for 30 lakhs, husband and wife. We have, my lord, around more than 1 crore terminal benefits.
So that's,
We cannot get away.
put it in the affidavit. We'll
But
ask
on a
the
requisition I have stated.
All right. Then we'll see. You see, your officials may not give NOC, but the court can pass an order and we'll pass it.
that is why my lord, clause 4, they have order issued by attached under the clause 4 of the 2016.
We'll make it time bound if we allow it.
Yes, sir.
Even if you don't give NOC, it has to be
That
treated.
is why
as
he
deemed
was
NOC.
directed to take a view, but language is not appropriate. But circular saying that you have to obtain a view from legal authority. And that is why they have confused with the problem.
What legal authority?
They have withdrawn that letter.
That they withdrawn that letter, which is at 350.
We are playing with the lordship of order anyway, my lord. Circumventing it.
Mr. A.C. Berger, Senior Counsel, assisted by Ms. M.D. appearing for the applicant, has produced a copy of the order dated 23/2023, issued by the manager bracket PNIR bracket plus of the LIC to submit that the prayer for issuance of NOC made by the applicant has been declined on grounds which are
On the basis of a circular
on the basis of a circular dated 3/11/2016
and 9/4/2019.
and 9/4/2019. Although the conditions laid down in those circulars are not met in this case. The learned senior counsel for the applicant therefore seeks time till Monday to place to assail the order dated 23/2023 by filing an additional affidavit. Prayer allowed. Let this case be listed again on 28
Additional affidavit and also the circulars.
as well as the circulars. Let this matter be listed again on 28/3/2023.
My lord, one humble submission. 28 mile I will be out of station.
29,
8,
29.
28, 29, 30 in connection with the treatment.
And 27.
Let us see.
27, my lord, 27, 28, my lord, 29, 29, 30, 31, my lord. Then on 2nd of, can it be, my lord, 2nd of,
No.
3rd of April?
Let it be on 24th then. Then tomorrow I am going to file.
Yes.
Let it be on day after tomorrow, Friday.
List the matter on 27. 27.
Okay.
27. Right. Obliged.
Time being materials, I can take it.
Lordship, in this case, Lordship, petitioner on 21/2023 filed an additional affidavit, Lordship. Our affidavit is already there, but on this new facts, Lordship, I have already forwarded it to the department and I am waiting for their response, Lordship.
No, there is no new facts, my lord. I have only incorporated one rule, my lord, and some orders wherein similarly situated persons were earlier given promotion, my lord. There is no new facts.
No, but you filed an
And
addition.
I filed an additional affidavit pursuant to a clarification that was sought by this honorable court. I tried to clarify that. And the basic.
When did you file it?
I filed on, my lord,
21, Lord, 201.
21/1, my lord.
And this matter is about,
21/1/2023, I filed.
what
And
is the matter about?
you know, basically, I am praying for a similar direction, which has been already issued by this court, wherein a person junior to me had already been promoted pursuant to directions of this honorable court. And the reasons for rejection of his case was also similar to the present petitioner, my lord. Same ground, he was rejected. I'll just place for a moment, my lord, just the order passed by this honorable.
But at the end of the argument also indicate a date when we can fix it. We'll give him at least 10 days time to obtain instruction and then dispose it of. This court would like to follow up fair and transparent.
I have
procedure.
laid. I have laid.
So you want to argue your case, you argue, but at the end of the day.
There is no point, my lord. There is no
That's
point.
what I'm saying.
Yes. Or will fix a date.
Yes.
Hearing date, my lord.
4th of April.
4th of April.
I'll take 15 days.
Huh?
In the meantime, I'll get the.
11th of April, 11th of
Lordship,
April.
Lordship.
Or Mr. H.K. Das, learned counsel for the petitioner, also heard Mr. P. Nayak, learned standing counsel SADU submit that although counter affidavit on behalf of the department has already been filed, yet in view of the additional affidavit filed by the petitioner, we granted another 2 weeks time to obtain instruction. First up, although urgency has been expressed in the matter by Mr. Das, learned counsel for the petitioner, yet considering the prayer made by Mr. Nayak, this matter is directed to be listed again on 11/4/2023. So as to enable him to obtain instruction and file rejoinder if so desired. First up, it is made clear that no further time will be granted to the learned standing counsel to seek instruction on the additional affidavit.
My please, Lordship, this case is covered by 3 judgment, reported judgment, I'm already first. Your Lordship, I'm briefly stating the fact. Your Lordship, I was appointed as an extra writer for the month of 3 months. That appointment my appointment is extended. 3 months for the extra writer against the permanent post. There is a permanent vacancy extra writer 1 post in Zonai sub-register office. Lordship, after 3 months appointment was with the approval of the respondent number 3, Inspector General of Registration. In such a way, they completed their 13 years service.
What is the order of appointment?
Your Lordship. Next. Annexure, photocopy of.
Yes, 25.
Page 20.
Then order of extension.
Extension, thereafter, in official record, they are extending.
No, but this is all you're engaged as on daily basis.
The daily basis, daily basis extending the services with the approval of the appointing authority. Then, in the meantime, I have filed 2 writ petition. I have nothing concealed anything. 2 writ petition. 1 writ petition, the direction is given. It is a DO appointment to regularize and release the allowance, etc. Nothing, no any allowance release, payment, nothing. Thereafter, again file 1 writ petition. Judgment is passed. The direction is given by the Honorable High Court to regularize and release the.
Where is the direction? Where?
Direction? Your Lordship. WBC file 81 first writ petition. Another writ petition. WBC. Euro. Page 44-46. WBC 7552/2015. Page 44-46.
So you want regularization of service?
Yes, ma'am.
That prayer has been rejected by the earlier round, earlier court. Why have you come again?
Your Lordship, there is a direction to regularize or to release the payment.
Where is the direction? Show me. Where is the direction to regularize?
Your Lordship.
Please read the direction to regularize your service.
It may be seen that petitioner was appointed as extraditor under the establishment of the respondent number 3 on the approval given by the Inspector General of Registration. High communication data demand. The said engagement was accorded only for a period of 3 months. To clear the pending works. Therefore, the engagement being a specific period, the period cannot be claimed the regularization. Contrary to the relevant recruitment rules for appointing extraditor. However, at the same time, the petitioner claims to have been working as extraditor from the date of the initial appointment till date. The writ petitioner is disposed of with a direction to the respondent. More particularly, respondent number 6 to cause a verification as to whether the petitioner is working as extraditor till date. On such verification, if it is found that the petitioner is still working as such, he shall be paid his salary, which is
due to him as soon as possible within the period limit of 3 months from the date of the receipt of the certified copy of this order. It is needless to observe that if there is a vacancy as submitted by the learned counsel for the petitioner will be given a fair chance. No any initiation till that is our claim. As there is a vacant post, since that date of appointment on daily wage basis, that extra post still vacant. Against that one, there is also I am showing the another annexure.
What has happened to your salary, area salary? You have received it.
Your what's it?
Area salary, you have received it.
No. Without any allowance, without that salary, we are servicing last 13 years.
But there is an order of the court, it has not been complied with.
No complaint.
You have not filed contempt case.
No, your lordship, what happened? See the Themaji sub-minister. By this time, he cannot contact with me. Now he's a very poor person. What is the COVID period that after I filed one contempt proceeding. Section 20, contempt proceeding was hit by that section 20. This contempt proceeding is dismissed. I am not suppressing anything. Annexure here. Your lordship, then I have no alternative way. Again, I come to, at least this what happened. Now I am going to be terminated after 30 years service without any announcement. Your lordship, another thing, during my service period, I have paid now. But that allowance also pending. Nothing. Your lordship, a very interesting matter. Last 13 years, I have given so much representation to the authority. Nothing at all, nobody consider anything. It's a gross violation. Hey, so I am submitting before your lordship reported decision. 13 years my services utilized the government, but no anything till today.
Yes, Mr. Dutta.
Your lordship, Sandra, as per Honorable Guwahati High Court, this authority concerned initiated interview. If I am failed, then rejected. No initiation. My service is utilizing. There is a sufficient record. I have collected.
Yes, you made a very strong point. Yes, let me ask him.
Yes.
As per my information, he is not in the office, he is not in duty as on today.
Yes, since when?
No, my lord. It is a false. It is a absolutely.
You have to now take your seat, let him finish, then you reply.
Moreover,
Take your seat.
department has already rejected his prior to filing of this petition.
We rejected where? Where is the order?
And we have filed our affidavit. Running page 78, lordship. In inviting a reference to your letter number cited above, I am directed to say that regulation is not permissible under the existing rules. If there is vacant post, he may apply against the vacant post if he has the eligibility criteria like other candidates. Okay, 13 it has been rejected.
And what about his claim for arrear payment?
Arrear, most probably he have last orders have most probably have not communicated with the department. Because area part of my instruction is silent.
Then you get us the information. We'll have it up to 4 weeks.
Government advocate can take
Are you appearing, Ms. Bora?
Not reflected.
But I have gone to the petition lordship. In the petition lordship, page 39, annexure K. The district registrar is Dhemaji has written to the Inspector General of Register regarding payment of his salary.
All right.
It is already
We take down hard Mr. M. Talukdar, learned counsel appearing for the petitioner. Also heard Mr. S. Dutta, learned standing counsel revenue and disaster management department appearing for as per number 1
and 3.
And 3, Mr. P. Nayak, learned SC finance for respondent number 2 and 5, and Miss M. D. Bora, learned government advocate Assam appearing for respondent numbers 3 and 6.
4 and 6.
4 and 6. 4 and 6. What about 3?
Yeah, I'm appealing.
See your opinion first. After hearing the submissions advanced at the bar, this court is of the view that the learned departmental counsel is required to obtain instruction and appraise the court as to whether all the area dues of the petitioner has been cleared in terms of the order dated 23/7/2018 passed by this court in WPC number 7552 of 2015. The learned departmental counsel to also obtain instruction and appraise this court as to whether there is any vacant post of extra writer in the establishment of respond number
6.
respond number 6. And if so, whether any steps have been initiated for filling up the said vacancy by way of regular recruitment. Let this petition be listed again after 4 weeks by reflecting the name of Ms. M.D. Boral and G. Assam in the cause list.
My lord.
You want a copy of this
My
order? A copy of this order we furnish to.
Your Lordship, my respectful submission before your honor.
Yes.
In the pending disposal of the writ petition, your Lordship may kindly be to direct the respondents for restrain or keep the abeyance in of the said lying vacant post extra item.
Let the instruction come, then we'll pass that order. You wait for some time. Let the instruction come, then we'll pass that order.
After 4 weeks.
Like, in the event
Yes,
of
next matter, yes.
And in this case, affidavit has been filed today, my lord, not yesterday, my lord. The respondent is filed
There was some miscommunication with my office and I was informed it was filed yesterday. But today, on checking the record, I got to know it was filed today.
Affidavit filed by whom?
By us, by respondent above.
All right, we'll have it next week then along with the
Yes.
affidavit.
My lord, the
Heard
date
Mr.
may be
U.K.
fixed.
Das, learned counsel for the petitioner. Also heard Miss
As das.
S. Das, learned counsel appearing for the respond number
Respondent number 2, my lord.
who submits that a counter affidavit on behalf of her client has been filed only today.
Yes.
Full stop. In view of the above, registry to tag the counter affidavit with the record of this case and list the matter for orders again in the next week. Miss M.D. Boral and G. Assam appears to respond number 1.
My lord, till then, in time may be continued.
Interim order passed earlier to continue until further orders.
My lord.
Item number 45, which I missed the item.
My
non-papers may be removed first. Item number 45, I was in.
Item number 45.
That part is your.
Acha, what do you want?
Just my name, Lordship may be reflected, except non-papers. Lordship.